Hey everyone, how are y'all? Okay, Braz, are you doing okay tonight? Cheryl, how are you tonight? Just Ann, how are you? Hey, White Widow baby. I threw the email thing in there for Nightbot. I don't guess he's come to work yet. Thank you, Cheryl. Oh, just Ann, I'm so sorry to hear that. Y'all keep just Ann and her family in your prayers, please. All right. Nightbot finally decided he was going to work. Hey, Tara, how are you? Just Ann, I understand, honey. I am so sorry to hear that. All right. Everybody, make sure that you do have your chat on the live chat option so you don't miss anyone's comments. I don't know why YouTube just don't make it like a standard thing so we don't all have to go back and change it every time. But hey, Nina, how are you tonight? White Widow baby, you doing okay? Thank you, Tara. Nina, I am doing good. Give me just a second. I am trying to get all my stuff moved around here. Hey, Emerald Queen. Werewolf Queen, how are you? Emerald Queen, did y'all get my email like a day or so? Not no, wasn't yesterday. What's today? Wednesday? Is today Wednesday already? Yes, it might have been Monday. I emailed y'all. Checking on y'all. Around for a few days. I wanted to come yesterday as it was one of our birthdays, but we had been busy with family. Wait, whose birthday was it yesterday, Emerald Queen? Wait, what a baby! I just saw your comment about just bushing around. That is too funny. Okay, y'all, give me like 2 seconds. Hey, Mariska, how are you? I haven't Oh, I hope that's not hit my mic. I haven't changed my calendar yet. See, no. Okay, that's fine, Emerald Queen. I had just emailed y'all. I was checking on y'all. Make sure y'all were okay. I gotta tear April off my calendar because I still haven't. Oh, yesterday was y'all's birthday. Well, happy birthday to both of y'all. Wait, why didn't I have y'all's birthday on my calendar? Because yesterday was Delene's birthday as well. No. Wait, y'all's was yesterday the 2nd. I'm thinking today's the 4th, y'all. Good Lord. Okay. So Emerald Queen, y'all's was the 2nd, right? I don't know why I didn't have it on the calendar, but happy birthday to both of you. Mariska, I don't know why I didn't. I try to get everybody um, who comes in here, I try to get their birthday put on there. Okay, hold on. I gotta tear this off of here. Okay. So April was gone. Let me put the calendar back up. Emerald Queen, you're very welcome, honey. All right, give me a second. Hopefully this doesn't hit the mic. I ain't got much room to work here, y'all. Oh my gosh. Well, shit. Okay. See, Scarlet, no, and it didn't work. Wait, Mariska, what didn't work, honey? Okay, I gotta change my other calendar too. My other one has got my Brian Kohlberger preliminary trial countdown thing or preliminary hearing countdown. You gotta keep it up to date too. Okay. Werewolf Queen, thank you so much for becoming a member. And of course, you've already been a part of the family. Well, so I must threw my damn phone across my patio. There was a spider crawling. Hey, Marissa. Wait, what a baby. I'm laughing with you, not at you. Okay. Now, both the calendars are fixed. 3 days late, but they're fixed. I am not okay. Did you smash him, White Widow baby? Marissa, you're very welcome. That is too funny. But like I said, I am laughing with you, not at you. All right. I'm trying to figure out what I want to do first tonight because I have so much to talk about. I might just hurry up and get through the Idaho 4 stuff because there was some new court documents that had dropped. Oh, see, I hope so. I smacked my arm and flung her. Oh my gosh. So I think I'm going to start with that one. And then we'll get into the 6 victims that were murdered in Oklahoma, the Texas mass shooter, because he was arrested last night. And then I got a little bit about the Atlanta shooting that happened today. There's been so much craziness going on in the last few days. Okay, Braz. Okay. Let's see here. So, y'all know that, was it last week before last? The Supreme Court turned down the media coalition's thing about getting rid of the gag order or whatever. And then there was a motion hearing scheduled for May the 25th for the Gonzalez family. Well, now the media coalition has decided that they're going to take it to a lower court. So they're still going to fight the gag order. Let me get this pulled up, which is what the court documents are over, but I'm going to read the article about it real quick, and then we will go over the court documents. I know one of them is like 40-something pages long. I'm not reading all 40-something pages tonight. I will drop the website to the Idaho or the state of Idaho website where you can look at all of them, all of the court documents. They have all of Brian Kohlberger's, they have all of Lori Daybell's, and they have all of Chad Daybell's. Hey, Bullets, how are you? So we will drop that once I am done reading this, unless White Widow Baby has the link on hand and wants to go ahead and drop it. If not, then I can drop it once I go over there. Let's see, I need a hell of a lot of therapy after the train wreck called Letitia's death today. Didn't something, Mariska, happen with the audio over there or something? And they had to get a sign language person or something like that? I've seen people talking about it on Twitter earlier. Let's see, I do one. Okay, thank you, White Widow Baby. Vapor, how are you? Okay. So it says the media outlets again request to lift the gag order in the Idaho killings case. And White Widow Baby just dropped the link that has all of the court documents on it. Hey, Brian, how are you? Vapor, I'm doing good, thank you. The link that White Widow Baby just dropped, it is the link that has all of the court documents in it. Each time that something new comes out, they put it on that website. Like I said, there is all of Brian Kohlberger stuff, everything for Lori Vallow Daybell, and then everything for Chad Daybell. And there's some other case on there. I don't know who it's for. I never heard of the person, but there's several different cases on there. Brian, the world, yes, it is going mad, crazy. Like, I don't know what's up with all these shootings, people killing people. Bunch of nonsense, if you ask me. Okay, so let me read this real quick, and then we're going to jump over into the court documents. All right, so it says legal efforts to abandon a wide-range gag order issued by the judge overseeing the case against Moscow homicide suspect Brian Kohlberger has been renewed after a ruling last week from Idaho's high court that denied one of the petitions. So attorneys for more than two dozen media outlets resubmitted filings Monday evening in the Second Judicial District Court in Latah County, Idaho, after the Idaho Supreme Court dismissed the complaint on procedural grounds. They seek to end the non-dissemination order, arguing that it suppresses the First Amendment rights. And if y'all haven't done so while I'm reading this, please hit the thumbs up. So, following the Idaho Supreme Court's guidance, interveners and now ask this court to vacate the gag order because it is vague, overbroad, unduly restrictive, and not narrowly drawn. The complaint signed by Boise-based attorney Wendy Olson read, "The gag order thus should be vacated." Hey, P. Fox, how are you? Leslie, how are you? So the petition was initially filed with the state Supreme Court in February. The 5 justices, however, ruled against accepting the case and unanimously decided that they did not find extraordinary circumstances warranting that the skipping of the legal steps. The complaint should first be filed in Idaho District Court. The opinion penned by Justice George W. Moeller said. Latah County Magistrate Judge Megan Marshall issued the gag order in January after Kohlberger's arrest. 2 weeks later, she expanded the parties to whom it applies. Presently, the order restricts law enforcement, attorneys for the prosecution and the defense, as well as attorneys for witnesses of victims and the victims' families, from commenting about the case outside of the court filings. 4 University of Idaho students, they were found stabbed to death at the off-campus rental home in Moscow in November, and the victims we know is Maddie, Kaylee, Xana, and Ethan. Hold on, I gotta get it scrolled up a little bit. So Kohlberger, 28, who at the time was a WSU graduate student, he was arrested 7 weeks later on December the 13th. He was charged with the 4 counts of first-degree murder and the 1 count of felony burglary in the case that qualifies for Idaho's death penalty. Brian, yes, they caught the Atlanta dude. They caught him after a few hours today, and then they also caught the Texas guy. Hey, Loaded Hot, how are you? Okay, I don't think there's anything else that we don't know as far as what's going on with this. So there's no point in reading the whole thing. I got stuff popping up on my screen everywhere. Okay, let's see. So the judge says that the gag order preserves the right to a fair trial. The shocking homicides almost immediately garnered national and international attention. In issuing the expanded gag order, Marshall said that it was necessary to preserve Kohlberger's right to a fair trial. There is a balance between protecting the right to a fair trial for all the parties involved and the right to free expression as afforded under both the United States and Idaho Constitution, she wrote. So Kohlberger's attorney Ann Taylor, chief of the Kootenai County Public Defender's Office, and Latah County Prosecutor Bill Thompson supported maintaining the gag order as it is written in the court filings. So Olson, a former U.S. attorney for the District of Idaho, now with the private law firm Stoll Reeves, filed the lawsuit on behalf of the Media Coalition. The group is led by the Associated Press and also includes the New York Times, the Washington Post, and a dozen Idaho news outlets. There's, I think, 30 total, I believe it is. So while we are disappointed that the Supreme Court denied the petition, the Media Coalition now has a clear path under Idaho law to challenge the gag order and vindicate these important First Amendment rights. Corey Caron, Olson's co-counsel in the case, told the Statesman last week in an emailed statement. Okay, and then as we know, the Gonzalez family, that is what they are actually going to court for on May the 25th. They're also challenging it. So it says 4 days before Olson filed the media petition with the Idaho Supreme Court, the attorney for the Gonzalez family filed a separate challenge to Marshall's order in her second judicial district court, but Marshall put that petition on hold until the high court's ruling. Shannon Gray, the Gonzalez attorney, requested that Marshall amend the gag order to remove attorneys for the victims' families from being barred from commenting, and Gray argued that he is not a party to the case. So it says, I am not an attorney of record involved in this case. I have played no part in the investigation, prosecution, or defense of the case, and neither the state nor the defense has shared any information regarding the case, Gray wrote in his February filing, adding that Marshall's non-dissemination order is overbroad and vague. So following the state Supreme Court's decision, Gray's case now moves forward with the appeal schedule for the hearing in Marshall's court at 10 a.m. on May the 25th. And then for the Media Coalition, they haven't scheduled a date yet. So let's get over to the court documents. Give me 1 second to grab those. All right, give me a second so I can grab that website. All right, let me get a second to come up. Like I said, there's 6 total that came out. Hey Jen, how are you? Did you get my tweet DM? I got one. Hold on, Jen. I got one earlier. Yeah, I got yours. Talking about Alec Murdoch. Scott, how are you? Okay, let's see which one we're going to start with. Anyone listen to Bullets a little bit today? Seeing the reason for such a broad gag order, are they trying to protect the integrity of evidence or to make sure that they can put an impartial jury together? Loaded Hot, they're claiming that they're trying to keep the integrity of the case, and also so he can have a fair trial, is what they're saying. Mountain Mama, how are you? Okay, let me see if there's any important. The first one that's on here is the one that's 46 pages long. Trying to see what all it is. And this one has a bunch of exhibits. Okay, give me a second. I'm going to pull this one up. Is there any truth of Bethany brother being a corner? Brian, I've never heard that. About Bethany's brother being a corner? I haven't heard that. Okay. I'm not reading all of this. This is just all the names. It's the declaration of Wendy J. Olson in support of motion to vacate and amend the non-dissemination order. It has all of the names in it. And it's just explaining all these exhibits. And all that. So I'm just going down. That's just saying who it was sent to. Okay, there's Exhibit A. Okay, and this is the stipulation for the non-dissemination order, which I believe we have already read all of these. Brian, where did you hear that from about Bethany's brother? Because that's a new one. That's a new rumor I haven't heard yet. Okay, so the non-dissemination order. Okay, so we've read all these, so there's no point in reading them over again. I'm just showing what is in them. This is a stipulation to unseal with the redactions. Thank you, Mariska. Hey, Cherokee Raider, how are you? Okay, so we've read over all these. And this is the longest one out of all of them. This is amended non-dissemination order. P-Fox, that's where it was heard from. Hey, Tree Baby, how are you? Okay, Exhibit E is the memorandum of support of the motion for appeal and our clarification of the amended non-dissemination order. A joke is what it is. P-Fox, that's why I laughed whenever I saw the name. Give me 1 second, y'all. Okay, I just had to answer something back. Hey, Crime Crazy, how are you? All right. So I'm just going through this, letting y'all know I'm not leaving anything out. This is everything that we've done went over before. Exhibit F is a complaint and declaratory relief. This is, let's see, wait, this is Whitcomb. Let me see if we have read this one. Oh, yes, we've read that one too. Okay. So all of these, they basically just put some of there's a non-dissemination order in there again. The amended one, so it looks like they've included all these twice. So over all the Bethany rumors, theories, conspiracy now Harsh has BK and BF in some kind of relationship. A loaded hot, honestly, the rumors that's been going on here lately is ridiculous. You sent me an email, Gigi? Okay, let me make sure I got it. Okay, give me just a second. Let me make sure I did get her email. Okay, Gigi, I got it. I will read it once I'm done here, okay? And get back to you. Okay. And then so that everything on here we have done went over and read them. P-Fox, I haven't gotten yours yet, but it may take it a few minutes to come in. Hey, King Scarlet, how are you? Okay, so we've went over that one. That's the one that has like the longest one. But all the rumors just going around is getting ridiculous. People hear stuff and then they run with it. They don't vet the information. They put it out as facts. And it's getting a little bit ridiculous. Sent it early this morning. Okay. Oh, it's 7:00. Okay. Okay, yes, P-Fox, I did get it. So I will read that one as well once I'm done on here, and I'll get back to you. But I did see what it was about. Stevie, how are you? Hey, Truth Seeker, how are you tonight? Anthony, how are you? Let's see where the redo made me sick. Okay, yeah, P-Fox. I saw who it was about. I'll for sure take a look at it. Okay, let me get this one pulled up now. Okay. Kimmy's Lounge, how are you? All right, so this is the memorandum in support of the motion to intervene. I don't know if it's pulled up for y'all yet. It may take it a second. Hey, Debbie. How are you? Okay. And then once again, it does say the state of Idaho versus Brian C. Kohlberger, and then it has like the whole media coalition list down below it. All right. And I don't believe this one we have read, so I'm going to read over it real quick for y'all. All right. So it says interveners are a coalition of media companies that, but for the amended non-dissemination order dated January the 18th of 2023, which is also known as the gag order, would gather more information about Mr. Kohlberger's arrest and prosecution and then make editorial decisions about whether and when to publish that information. And can everybody see this okay, or do I need to zoom it in a little bit? Let me zoom it just a little bit. Danielle, how are you? Okay, zoom it in, but I'm on the phone. Okay. Let's see. I don't know how. I know if I zoom it in too much, I can't see all the words, but maybe that should be good right there. Night Buttonies. Stevie, he was late for work tonight. Act like he didn't want to start posting stuff when me and White Widow Baby was putting it in the chat. Okay. So it says the state and Mr. Kohlberger, which is the party, stipulated to what ultimately became the gag order, and the interveners were not given an opportunity to submit any written or oral objections in the approximately 1 hour between the parties submitting their stipulation and the court issuing the original gag order in the case. So because the gag order violates interveners' rights under the U.S. and Idaho constitutions, they petitioned the Idaho Supreme Court to vacate the gag order. Last week, the Idaho Supreme Court held that a vague, overbroad, unduly restrictive, or not narrowly drawn gag order is an unconstitutional obstacle to interveners gathering information about the case. And then they put in, petition for the writ of mandamus or the writ of prohibition. Go down a little bit here. So it says, but on procedural grounds, the Idaho Supreme Court decided that this court should have a chance in the first instances to vacate the gag order. Can I ask everyone to pray for my daughter? She's starting chemo for breast cancer. Please get name is Jennifer. Debbie, yes, we can keep your daughter in our prayers. I hate that she's going through that. I hope that she, everything goes well for her in her treatments. And please let her know that we're going to be keeping her in our prayers. And Danielle, you're very welcome. Okay, so it says that the Idaho Supreme Court declined to exercise its original jurisdiction because interveners have an available remedy. The Idaho Supreme Court acknowledged that Idaho's rule of criminal procedure do not provide a specific mechanism for third parties to intervene in a criminal case, but they observed that both state and federal courts often permit the media to intervene in criminal cases on a limited basis, or at least file a motion as interested parties in the defense of public access and free speech, including in Idaho. Following the Idaho Supreme Court's decision to first seek relief before this court, the interveners now move to intervene for the limited purpose of contemporaneously filing their motion to vacate the amended non-dissemination order. So that was signed by or sent by their attorney on the 1st of May. And that's attorney Wendy Olson. Okay, and it was sent to the prosecutor, Ann Taylor, and then the one deputy attorney general, which is Jeff Nye, and then it was also sent to Shannon Gray. All right, so that is one of the memorandums. Give me just a second. I'm gonna go grab the next one. Let's see what it is. That's where this happens to your family. Okay, I'm just trying to keep up with chat also real quick. Let's see. This one may be a little bit long. Try to get through it as quick as we can because I don't think we've read over this one either. Hey, Michelle. Okay, so this is the memorandum in support of the motion to vacate and the amended non-dissemination order. Okay, once again, it's State of Idaho versus Brian C. Kohlberger. It also has all of the media coalition companies listed. Scarlett, a crazy new YouTuber I got sent, but I'm scared to admit more and more like her. Who was it, Brian? And why would you be scared to admit that you like a creator that someone told you about? Let's see, my chat keeps jumping from all to. Just saying, it's been doing that here lately. Mine does that sometimes, and I have to keep putting it back on live chat. Okay, so what I'm just scrolling through right now is just a table of contents on here. This is the introduction. Trying to see what else is on here. It kind of tells what's going on with the case, why they're doing it all, what their argument is, and all that. Okay. It's kind of lengthy, but I will try to get through it as quick as I can. Let's see. Interesting. Brian. Okay. Let me get to read this. Brian, I'll email you later, okay? All right, so the introduction. It said, yeah, sorry. It says last week, the Idaho Supreme Court confirmed that a vague, overbroad, unduly restrictive, and not narrowly drawn gag order is an unconstitutional obstacle to interveners gathering information about the case. But on procedural grounds, the Idaho Supreme Court decided that this court should have a chance in the first instance to vacate the amended non-dissemination order entered on January the 18th of 2023. Stevie, no, he doesn't know. So, following the Idaho Supreme Court's guidance, interveners now ask the court to vacate the gag order because it is vague, overbroad, unduly restrictive, and not narrowly drawn. The gag order expands far beyond the Idaho rule professional conduct 3.6, applying to individuals not governed by those ethical rules and prohibiting any statements about the case, not just those that present a substantial likelihood of materially prejudice and a future trial. Hey, honey, how are you? Cami, how are you? Woods 2323, how are you? Let's see, Scarlett. So is SG asking in this filing for his attorney to be able to speak on the family's behalf? Danielle, the Gonzalez family's attorney is trying to say that he shouldn't be under the gag order because he doesn't play a part in the case. Like he's not a party to it. And so he's basically trying to get out from under it. Okay, y'all, I've done lost. I was paying attention to chat and done lost my spot. Give me just a second. Okay. Okay, here we go. Hey Shane, how are you? And if anybody's come in that I haven't spoke to, I do apologize, but thank you so much for joining us tonight. I said, what's more, the state and Mr. Kohlberger, the parties, have submitted no evidence that media coverage presents a sufficient risk of perjury, prejudice to Mr. Kohlberger's right to a fair trial, or that other remedies are insufficient to prevent or remedy any prejudice. The gag order, which is based on the party's stipulation, rests merely on an assumption that press coverage is bad. The U.S. Constitution and the Idaho Constitution damned more. The gag order should thus be vacated. Hey, Dreamcatcher. Let's see. I think they put the gag order in place to shut SG up, or at least slow him down. I think the reason 9mm that that they're wanting out from under it so bad is I think Mr. Gonzalez wants to speak. I think he's got something to say, and I don't know if it has to do with maybe all the rumors that's going around, um, or what it is. Oh my God, Stevie. Hey, LJ, how are you? Ray, how are you tonight? Okay, so the second part of this is the background. Kind of like me, nuts but bright. Okay. Like I said, Brian, I'll email you later, Brian, about it. So in December of 2022, Brian C. Kohlberger was arrested and charged for allegedly murdering 4 students at the University of Idaho. Despite the great public interest in the investigation of the murders and now the prosecution of Mr. Kohlberger, there have not been any notable leaks or dissemination of extrajudicial information that would prejudice Mr. Kohlberger's right to a fair trial. Yet the parties stipulated to a gag order prohibiting attorneys, investigators, and law memorandum. Hold on. Law enforcement personnel from making any extrajudicial statement, written or oral, concerning this case, other than a quotation from or reference to, without comment, the public records of the court in the case. And it's saying, okay, so the declaration of Wendy J. Olson, which is the Media Coalition's, their attorney. Let's see, I'm good. And got out of rehab. Oh, Ray, that is awesome news. So the declaration of Wendy J. Olson, which is Exhibit A, the parties offered no evidence in support of their stipulation, simply asserting, as the court is aware, the case involves matters that have received a great deal of publicity. It's literally everybody all over the world has heard of it. Hey, Tonka, how are you? American Princess, how are you? Gigi, how are you tonight? All right, so it says their assertion, while not wrong, does not say the publicity has been prejudicial to Mr. Kohlberger. The court issued the requested gag order just over an hour after the parties submitted their stipulation, which was Exhibit B. Interveners do not doubt that the court had good intentions, but an hour was not enough time to meaningfully consider the constitutional interests at stake. There was no time for the court to hold a hearing, take any objections, make factual findings, or perform any legal analysis. They just literally just threw it out there quick. 10 days later, the court held a private meeting with the parties and an attorney for a victim's family, which is, and they're saying Exhibit C and all this, that, which is what we just went through, which is the documents that we have already covered. So the parties drafted a memorandum after the meeting. The memorandum is not a court order, it is the parties' memorialization of what they remember from the meeting. Even though minor redactions would satisfy any privacy concerns, the parties opted to file the entire memorandum under seal. To the public, it appeared that the meeting never occurred. The parties later agreed to unseal the memorandum to use it to oppose the intervener's petition in the Idaho Supreme Court. 5 days after the private meeting, the court issued a gag order that is at issue in the motion, which is Exhibit D. Because the preceding meeting was held privately to the public, it appeared that the court issued a gag order sua sponte, probably not pronouncing that correctly. The court noted in the gag order that to preserve the right to a fair trial, some curtailment of the dissemination of information in the case is necessary and authorized under the law. The court made no factual findings in support of that conclusion, which of course it could not, as again the parties presented no evidence. If evidence was presented during the private meeting, it was not offered on the record and cannot be relied upon, as interveners have no means to evaluate, let alone challenge, the veracity of the evidence. Nor did the court hold a hearing or offer any legal analysis aside from a footnote citing several authorities and offering no explanation of how or why those authorities apply. Give me just a second, y'all. Okay. Let me get back over to this. So the gag order extends beyond what the parties requested in their stipulation. The gag order applies to the attorneys for any interested party in the case, including the prosecuting attorney, defense attorney, and any attorney representing a witness, a victim, or victim's family, as well as the parties to the above entitled action, including but not limited to investigators, law enforcement personnel, and agents for the prosecuting attorney or the defense attorney. Hey, Obsessed for Disneyland, how are you? So interveners are a coalition of media companies that, but for the gag order, would publish more information about the murders at the University of Idaho and Mr. Kohberger's prosecution. Members of the media coalition have been affected by the gag order as follows. A victim's family wants to speak with the press about Mr. Kohberger's prosecution, but they feel bound by the gag order. I would assume that would probably be the Gonzalez family. Just my opinion. Hey, Kim, how are you? A Washington agency has requested declaratory relief to determine whether, consistent with the gag order, it can produce the 911 tapes in response to the public records request. I wonder why they're holding on to that 911 call, though. Like, for some reason, they don't want it out to the public. And Valerie, how are you? So, Major Christopher Paris of the Pennsylvania State Police told reporter Chris Ingalls that he could not answer whether police had launched any review of unsolved cases that could be linked to Mr. Kohberger because of the gag order. Moscow Mayor Art Bedich told reporter Erica Zuko that the city attorney advised that he could not answer any questions about the overall community healing in Moscow because of the gag order. What would it have hurt for them just to say, yes, the community is in the healing process, or they're trying to heal? All right, so journalist Taylor Murfindersky, public records request was denied by the Latah County Sheriff's Office, Moscow Police Department, Pullman Police Department, and Washington State Police Department because of the gag order. The Moscow Police Department issued a press release that, due to the court order, the Moscow Police Department will no longer be communicating with the public or the media regarding the case. Gary Jenkins, the chief of police at WSU, and Matt Young, communication coordinator for the city of Pullman, told reporter Morgan Romero that they could not answer whether Mr. Kohberger applied for a graduate assistant research position with the Pullman Police Department because of the gag order. Hey, who's that girl? How are you? Okay, wait, what up, baby? Okay. So the Moscow Police Department refused to advise a reporter from the Idaho Statesman how many cell phone towers are in the area near where the murders occurred, the size of Mr. Kohlberger's cell, the size of the Moscow jail, and the nature of Mr. Kohlberger's meals because of the gag order. They can't even tell people what Brian is eating in jail. Let's see, LSCC, appreciate you discussing info actually related. LJ, you're very welcome, and I appreciate you coming and hanging out with us. All right, so law and crime reporter Anjanette Levy was denied access to Kohlberger's booking video from the Latah County Sheriff's Office because of the court's non-dissemination order. So within weeks of the court issuing the gag order, interveners petitioned the Idaho Supreme Court to vacate or nullify the gag order. The Idaho Supreme Court held that interveners have sufficient standing to challenge the gag order. So, in support of that holding, the Idaho Supreme Court agreed that the injury claimed a claim that the gag order infringes freedom of the press by restricting the interveners' ability to gather information for publication is recognized under the First Amendment. The Idaho Supreme Court further noted that if the gag order is vague, overbroad, unduly restrictive, or not narrowly drawn, it would be an unconstitutional obstacle for their gathering of such information. Made a call from the phone. I don't have it. Danielle, I heard the same thing. Who did? Well, what I heard was that Ethan's best friend had made the call with Dylan's phone. Um, and then that was said from News Nation. Hey sis, how are you? Um, and of course it was, from Banfield sources. But then it later on came out, and I'd seen where they said that the best friend turned out to be Hunter. Now, I don't know if that's true or not, but I mean, it could be because him and Ethan and Hunter were really good friends. There's videos of them singing together. They were always hanging out together. So I mean, it could have been him, but we're not really going to know any truth on it for another 52 days. So having his attorney removed from the gag order isn't going to give Steve Gonzalez any more information that he gets now. Now, I don't think he's going to get anything else as far as information, King Scarlet. I think Mr. Gonzalez wants to talk. I think that's what that is. Okay, give me. Okay, never mind. All right. I was looking at something and was trying to respond to a comment. All right, what little baby, did you get it fixed? Let's see, did you see the statement Kaylee's sister released on why they're contesting the gag? No, sis, I didn't see that. And Danielle, you're very welcome. Okay, so third part of this is their argument. So it says justice cannot survive behind the walls of silence. For that reason, a responsible press has always been regarded as the handmaiden of the effective judicial administration, especially in the criminal field. The press does not simply publish information about trials, but guards against the miscarriage of justice by subjecting the police, prosecutors, and the judicial processes to extensive public scrutiny and criticism. The memorandum in support of the motion vacated Okay, hold on, y'all, because I don't know why they're putting the name of the dang thing that close to the actual paragraphs. But the First Amendment was thus intended to give the liberty of the press the broadest scope that could be counter-entrance in an orderly society. Hold on, I gotta zoom this in a little bit more because I can't see it. So, to be sure, an orderly society must also consider a criminal defendant's right to a fair trial. But when balancing that interest, First Amendment protections do not yield again until they infringe the Sixth Amendment. There is no presumption that speech is prejudicial to a criminal defendant or that more speech necessary means a less fair trial. To the contrary, the U.S. Supreme Court's precedent demonstrates that pretrial publicity, even pervasive, adverse publicity, does not inevitably lead to an unfair trial. Yeah, I just can't talk tonight for some reason. And even when speech is prejudicial to the criminal defendant, only in relatively rare cases does pretrial publicity present unmanageable threats. Many mitigating measures exist, including change of venue, trial postponement, a searching voir dire, empathetic jury instructions, and the sequestration of the jurors. So, to ensure a proper balance between the First and Sixth Amendment, a party requesting a gag order must present evidence that prohibited speech presents a sufficient risk to prejudice to a fair trial, and that none of the other alternative remedies, which do not prohibit speech, are sufficient to prevent or remedy any prejudice. Let's see. Harmony for Tranquility, how are you? So you've been a while since I've been able to catch you live, listening, and working. Well, thank you for joining us, Harmony. All right, so it says here the parties have fallen well short as they have submitted no evidence on the record to support the sweeping gag order that is in place. So it says A, the gag order violates the First Amendment because it is vague, overbroad, unduly restrictive, and not narrowly drawn. The gag order broadly prohibits any statements concerning the case. That prohibition is much broader than the Idaho Rule of Professional Conduct 3.6, and it is broader than the regulations of speech described by the U.S. Supreme Court in Shepherd, Nebraska Press and Gentile. There is no evidence that every statement concerning Mr. Kohlberger's prosecution poses a substantial risk to his right to a fair trial, nor is there any evidence that other less restrictive measures could not prevent or remedy any prejudice. As a result, the gag order violates the U.S. Constitution and the Idaho Constitution. So it says, number one, the gag order far exceeds Idaho Rule of Professional Conduct 3.6. So footnote 1 of the gag order cites that the Idaho Rule of Professional Conduct 3.6. It is unclear whether the citation is intended to suggest that the gag order mirrors Rule 3.6. Even if that were the case, the parties need to explain why the Idaho State Bar's enforcement of Rule 3.6 is insufficient, such that a court order and the penalty of contempt are necessary. Those more severe penalties present a unique chilling effect that will reduce speech that does not violate the Rule 3.6. And that is all the gag order does. It allows the rumors to run rampant. They know that they can get up and say whatever they want, and nobody can defend it because of the gag order. So I think the gag order is because there's things these families and Ellie doesn't want the public to know about. That could be true, Tonka. I don't know. They're fighting this gag order hard, though. Okay, so it says A, the gag order broadly prohibits any statements about Mr. Kohlberger's prosecution. So Rule 3.6 is carefully crafted to regulate a narrow set of topics that are most likely to be prejudicial. It regulates speech that will have a substantial likelihood of materially prejudicing and objective proceedings in the matter, IRPC 3.6a. The rules comment explains that there are certain subjects that are more likely than not to have material prejudicial effects on the proceedings, such as the character, credibility, reputation, or criminal record of a party. The possibility of a plea of guilt to the offense, or the existence of or contents of any confession, admission, or statement given by the defendant. The performance or results of any examination or test, or the refusal or failure of a person to submit to an examination or test, and any opinion as to the guilt or innocence of the defendant. I see 12 blisters and now, and I know now it's not a troll that's going sidekick. Okay, I'm trying to keep up in chat to y'all while I'm reading this. Danielle, thank you for that comment. That was very nice. Okay, so by contrast, the gag order is not tailored at all. Section 1 of the gag order prohibits any extrajudicial statements, written or oral, concerning the case. Let's see. So, Exhibit D, which Section 2 offers examples of the prohibited speech, but it does not say those examples are exhaustive or limited to the general publication of any statements concerning the case, and as a result, the gag order prohibits all statements about Mr. Kohlberger's prosecution, even statements that could help him secure a fair trial. Unsurprisingly, then individuals have said that the gag order prohibits them from making comments on innocuous topics like how the Moscow community is healing. Honestly, like, how is that going to hurt anything just by letting people know how the community is doing? Hey, Gregory, how are you? So the size of Mr. Kohlberger's sale, the meals that Mr. Kohlberger receives, or Mr. Kohlberger's job application to the Pullman Police Department. Even without the sweeping prohibition in Section 1, Section 2 of the gag order does not precisely mirror Rule 3.6 commentary. For example, Section 2A prohibits speech on evidence regarding the occurrence or transactions involved in the case, which is broader than the commentary's concern about speech related to the identity or nature of a physical evidence expected to be presented. IRPC 3.6 5 and Section 2D prohibit speech about any opinions as the merits of the case or the claims or defense of a party, which is broader than a commentary's concerns related to speech about any opinion as to the guilt or innocence of a defendant. All right, so the IRPC 3.6, let's see, 5, which also covers in Section 2F, suggesting Section 2D, is intended to regulate something different and broader. So Part B says the gag order prohibits speech from a broad and vague group of individuals. The gag order targets the attorneys for any interested party in the case, including the prosecuting attorney, defense attorney, and any attorney representing a witness, victim, or the witnesses' families, as well as the parties to the above entitled action, including but not limited to investigators, law enforcement personnel, and agents for the prosecuting attorney or the defense attorney. To start, that group of individuals is vague. Although the gag order expressly identifies certain types of individuals, the list is not exhaustive because of the phrase including but not limited to. As a result, others like the victims' families and law enforcement outside of the state of Idaho must guess whether they are subject to the gag order. Well, the guy out in Pennsylvania, I forgot what his name is, that was given information. He didn't act like he was too concerned about the gag order. Wait, is today Marissa's birthday? I don't have her birthday wrote down either. See, it's not until the 8th. We're going to see my daughter. Oh, see, Marissa, I didn't have your birthday wrote down. Okay. Well, I got it wrote down now, and I'll put it on the calendar tonight. All right. So it says that guessing game renders the gag order unconstitutionally vague, and it also exceeds the court's jurisdiction, as the court cannot bind individuals who are not before it and who reside outside of Idaho. So that group of individuals is also overbroad. In contrast to the gag order, Rule 3.6 governs attorneys only, and specifically those attorneys admitted to practice in Idaho. Rule 3.8 demonstrates a limitation. It requires the prosecutor to exercise reasonable care to prevent investigators, law enforcement personnel, employees, or other persons assisting or associated with the prosecutor in a criminal case from making statements that the prosecutor cannot make under Rule 3.6. That is, Rule 3.8 operates indirectly through the prosecutor. It does not apply directly to an investigator or law enforcement because they are not lawyers admitted in Idaho. Nor does Rule 3.8 address the defense attorneys, the defense's investigators or agents, or the attorney or give me a second, y'all. I just want to look at something real quick. Okay. All right. So the U.S. Supreme Court precedent counsels in favor of vacating the gag order. So the court cited 3 U.S. Supreme Court decisions in footnote 1 of the gag order: Shepherd, Nebraska Press, and Gentile. With those cases acknowledged proprietary of regulating some speech from lawyers and trial participants, they also explain the findings of prejudice and the narrow tailoring of that are required before prohibiting speech. The party stipulation and the gag order ignore those principles. So, taking the cases in order, the U.S. Supreme Court first decided Shepherd versus Maxwell, 384 U.S. 333, 1966. There, a prisoner challenged his conviction, arguing that he did not receive a fair trial because of publicity before and during the trial. For example, Shepherd's jurors were subjected to newspaper, radio, and television coverage of the trial while not taking part in the proceedings. 3 months before the trial, Shepherd was examined for more than 5 months without counsel, which was televised live from a high school gymnasium seating hundreds of people. See, I'm done now. Wait, what are we done about? I've done missed a whole dang good conversation because y'all are all just in here laughing. Ray, wish your youngest son a happy birthday from all of us, please. Okay. Wait, what a baby. You and Charlie are going to have to catch me up later on what's so funny. Stevie's telling me don't look. I can't know, Lord, y'all. See, May 25th is Maddie's birthday, the same day as the first court date. Yes, that is true, Mountain Mama. Cherokee Raider, how are you? Wait, I'm telling y'all I'll do some. Brian, if you only knew. Honestly. Okay. So it says during the trial, the lower court erected a press table for reporters inside the bar, where some 20 reporters sat within a few feet of the jury box. The lower court also assigned almost all of the available seats in the courtroom to the news media. Together, those decisions interfere with the privacy and tranquility of the defendant, the witness, and the jury during the trial. The expert, how are you? Hey, Gina Marie, how are you? So, as a result of all of those and other facts, the court held that Shepard did not receive a fair trial consistent with the Due Process Clause of the 14th Amendment. Hold on. Okay. So, in support of that holding, the court noted that the trial judge's failures to prevent or remedy any prejudice to Shepard using remedies such as continuance of trial, sequestration of the jury, and control of the courtroom. Interveners acknowledged that one potential measure the court mentioned was that the trial court might well have prescribed extrajudicial statements by any lawyer, party witness, or the court official which divulge prejudicial matters, such as the refusal of Shepard to submit to interrogation or take any lie detector tests. Any statements made by Shepard to officials, the identity of prospective witnesses, or their probable testimony, any belief in guilt or innocence, or the like statements concerning the merits of the case. So, but the observation does not compel maintaining the gag order. To start, Shepard is a due process case, not a First Amendment case. Nobody appeared to argue that the prescription suggested by the court would violate the First Amendment, so that the court did not decide that issue. Shepard also largely addressed conduct during the trial, which is for now is not an issue, as Mr. Kohlberger's trial has not even been set and is likely many months or years away. More than likely, probably many years. So it says, and to be clear, interveners do not seek to conduct an out-of-court examination of Mr. Kohlberger or to sit within the bar at Mr. Kohlberger's trial. While those stark legal and factual differences means that Shepard is not controlling, more importantly, the gag order here is not the hypothetical order that Shepard described. There, the court contemplated an order limiting speech on prejudicial matters, such as the refusal of Shepard to submit an interrogation or take any lie detector tests, any statements made by Shepard to officials, the identity of the prospective witnesses or their probable testimony, any beliefs in guilt or innocence, or like statements concerning the merits of the case. As described above, the gag order is much broader. It prohibits any statements concerning the case, regardless of how likely or unlikely the statement is to be prejudicial or helpful to Mr. Kohlberger. So the court next decided, Nebraska Press Association versus Stewart. The gag order there prohibited the statements about A, the existence and nature of any confessions or admissions made by the defendant to law enforcement officers, and B, any confessions or admissions made to any third parties except members of the press, and C, other facts strongly implicated of the accused. So even with that narrower scope of prohibitions, the court held that the gag order was unconstitutional. While drawing that conclusion, the court explained the three principles that are relevant here. First, the First Amendment and the Sixth Amendment are entitled to equal protection, as the court explained. Hold on, y'all. I gotta fix this where it won't. Shit. Why is it not want to do right? Okay. Can everybody see this okay? Okay. Thank you, Michelle. Thank you, Gregory. All right, so it says the court explained that the authors of the Bill of Rights did not undertake and assign priorities as between the First Amendment and the Sixth Amendment rights, ranking one as superior to the other. let's see, at 561. It is thus not the courts to rewrite the Constitution by undertaking what the founders declined to do. Instead, First Amendment rights should yield only when necessary to protect the Sixth Amendment rights. There is a need to protect the accused as fully as possible, and a need to restrict publication as little as possible. The second and related principle is that courts should consider other measures before issuing a gag order. The court endorsed many alternatives, such as a change of trial venue to a place less exposed to the intense publicity that seemed imminent in Lincoln County. I just don't know if they can do that with Bronze, though. Like, everybody has heard about it. All right, so B, the postponement of the trial to allow public attention to subside, searching, questioning of prospective jurors, as Mr. Chief Justice Marshall used in the Byrd case, to screen out those with fixed opinions as to guilt or innocence. And D, the use of emphatic and clear instructions on the sworn duty of each juror to decide the issue only on evidence presented in open court, and the sequestration of jurors. By considering these alternatives, in other words, by narrowly tailoring the remedy, courts ensure that they are issuing gag orders only when necessary. As a result, the First Amendment is infringed only when necessary to protect a Sixth Amendment interest. That approach preserves an equal balance between the two rights as intended by the founders. So the third principle is that when reviewing the above analysis, a reviewing court must examine the evidence before the trial judge and the precise terms of the restraining order at 562. Based on these other principles, Nebraska Press held that the gag order there was unconstitutional. The court observed that pretrial publicity, even if pervasive and concentrated, cannot be regarded as leading automatically in every kind of criminal case to an unfair trial. Given that the assumptions are inappropriate in the context, the probability of prejudice was not demonstrated with a degree of certainty. The gag order was also not properly tailored. The trial court there failed to consider alternatives short of a gag order, and the prohibition of the implicative information was too vague and too broad to survive the scrutiny required. Okay, yeah, and I'm trying to keep up with this and the chat, so if I'm missing something, I do apologize. Okay, so in many ways, Nebraska Press counsels in favor of the vacating the gag order here. The parties offered no facts of the court to determine that any statement concerning the case or concerning his case was prejudice. Mr. Kohlberger, the parties also offered no explanation of why alternative measures would not suffice. But even if they had, the precise terms of the gag order, which prohibits statements concerning the case, are broader than the Nebraska Press gag order, and that the U.S. Supreme Court held was too broad. So last, the court decided Gentile versus State Bar of Nevada. There, an attorney challenged disciplinary actions taken against him for allegedly violating Nevada's equivalent of Idaho Rule of Professional Conduct 3.6. Like the Idaho rule, the Nevada rule prohibited an attorney from making an extrajudicial statement that a reasonable person would expect to be disseminated by means of public communication if the lawyer knows or reasonably should know that it will have a substantial likelihood of materially prejudicing an adjudicative, hold on, y'all, I'm trying to get this straight. So adjudicative proceeding. The court held that the rule was unconstitutional as interpreted and applied in Nevada. Hold on just a second. Okay. So the court's decision was fractured, but Part 2 of the Chief Justice Rehnquist opinion garnered a majority and is relevant here. So the Chief Justice Rehnquist first observed that by default, the First Amendment requires a showing of clear and present danger that is a malfunction in the criminal justice system, which will be cause before a state may prohibit media speech and publication about a particular pending trial. See. Hey, Jan, how are you? Okay. All right. So that said, the law imposes a less demanding standard for regulating speech of lawyers representing clients in pending cases because those lawyers are participants in the criminal justice system, and thus the state may demand that some adherence to the precepts of of that system. So, a substantial likelihood of material prejudice test satisfies that less demanding standard as is imposes only narrow and necessary limitations on speech. The restraint on speech is narrowly tailored. Okay, I'm just making sure. I just want to make sure I haven't missed anybody coming in into chat. All right, so in sum, Shepherd, Nebraska Press, and Gentile all counsel in favor of vacating the gag order. Those cases only permitted prohibitions on speech that are one, justified by a risk of material prejudice, and two, narrowly tailored to limit only the speech that is actually prejudicial and cannot be prevented or remedied through other means. The parties have submitted no evidence of the prejudice sufficient to justify a gag order, clear and present danger for non-lawyers, and substantial risk for material prejudice for lawyers. And even if they had, the gag order is not narrowly tailored, surgically prescribed only the speech that is prejudicial and cannot be prevented or remedied through other means. Okay. Okay. So it says 3, the court should treat the gag order as a prior restraint and apply strict scrutiny. So consistent with the principles articulated in Shepherd, Nebraska Press, and Gentile, the court should treat the gag order as a prior restraint and vacate it because the party's request does not survive strict scrutiny. The gag order is a prior restraint. Let's see. The speech presupposes a speaker and a recipient. See, and I'm not reading all these different cases on here. So without one, there cannot be another. We have recognized that without some protection for seeking out news, freedom of the press could be eviscerated. So the right to speech necessarily protects the right to receive information and ideas. There is thus a constitutionally guaranteed right as a member of the press to gather news. Okay. All right, so the gag order restrains that the constitutional right before it can be exercised. Interveners do not make the news; they report the news. They cannot report what they cannot gather. There are many sources of newsworthy information, but for the amended gag order would provide information to the interveners, and the interveners would then make editorial decisions about whether and when to publish. So the intervener's speech is thus being restrained before they can even speak. That is the definition of prior restraint. So if the amended gag order is a prior restraint, then it is subject to strict scrutiny. So number 4 says the court should reject the fiction that gag orders directed at trial participants do not restrain the press. So to avoid the outcome dictated by the prior restraint, jurisprudence in cases like Shepherd, Nebraska Press, and Gentile, the interveners anticipate that the parties will ask the court to follow the Second and Ninth Circuits in applying for the First Amendment, definitely when the media challenges gag orders directed at some source of information. The court should reject those decisions because they are not well reasoned and place form over function. Hold on, y'all. I gotta scroll down through all of this other stuff that they have included in this. So, in the Ninth Circuit, recognized that the media has a First Amendment right to access the right or right to gather information. But the Ninth Circuit's view, a court order prohibiting an individual from speaking with the media does not infringe the right to gather information because the media has never has any guarantee of or right to interview counsel in a criminal trial. Trial counsels are, of course, free to refuse interviews whether or not restrained by the court order. If such an individual refuses an interview, the media has no resource to relieve based upon the First Amendment. So that reasoning is misguided as a court prohibiting a person from speaking to the media is different than an individual deciding not to speak to the media. To start, an interviewee's decision not to speak to the media is generally not a state action. As a result, the First Amendment typically does not govern the interviewee's decision to not answer questions. So, by contrast, a gag order issued by the state court, even to enforce the request of a private party, is a state action and thus must comport with the First Amendment. They are putting all kind of stuff up in this thing, ain't they? All right, let me get past all this other. Okay, so it says the Ninth Circuit's reasoning also ignores the reality of the news coverage. There is no reporting without information. The media does not make the news, it reports the news. If a court orders an individual not to provide information to the media, then the media has nothing to report. The media may technically be allowed to ask questions to gather the news, but it has no real expectations of an answer. Hey, Boomer Girl, how are you? So the law should recognize, or at least assume, that individuals will follow court orders. As a result, a court order regulating an individual's speech to the media also regulates the media. The media has no realistic opportunity to publish the information that the sources of information are ordered not to provide. So the interveners are not, as radio and television news suggests, seeking an order compelling anybody to speak with them. Instead, they are challenging the state action prohibiting a speech and asking for a realistic opportunity to gather and report information on a matter of the public interest. Okay, so the Second Circuit's decision in the application of the Dow Jones and Company is also pervasive. So the court's analysis there begins by observing that the distinction observed in radio and television news, which is flawed for the reason already described. The Second Circuit additionally noted that the parties subject to the gag order are requested that the order and urge its affirmance. A party's preference not to speak with the press does not mean that the state action adopting the preference is lawful. A party's preference not to speak is typically not a state action, but it becomes a state action when a court issues an order. Angie, how are you? Okay. So given the flawed reasoning in the radio and television news in Dow Jones, the court should reject those decisions and adopt a better reasoned decision in Young and People versus Sledge. In Young, the Sixth Circuit recognized that the media had no realistic opportunity to gather and publish the news when a court forbids sources of information from talking to the media. Although the news media are not directly enjoined from discussing the case, and it is apparent that significant and meaningful sources of information concerning the case are effectively removed from them and their representatives. Hey, Candy, how are you? So although the gag order does not directly prohibit the media from discussing the case, it prohibits the most meaningful source of information from discussing the case with the media. Therefore, the right of the media to obtain information from all potential trial participants is impaired. Simply put, radio, television, news, and Dow Jones puts form over function. They observe a technical distinction between gag order naming the media and a gag order naming a third party, but they ignore that in reality, both sides directly regulate the media. We have recognized that without some protection for seeking out the news, freedom of the press could be eviscerated. Young and Sledge understands that reality. The court should follow the better reasoning in Young and Sledge and hold that the gag order must be narrowly drawn and cannot be upheld if reasonable alternatives are available having a lesser impact on the First Amendment freedoms. Candy, it's nice to see you as well. Bonnie, how are you? Okay, I hope I haven't missed anybody else coming in. Okay, y'all, we're almost done with this file. So it says number 5, the court should apply strict scrutiny even if it does not find that the gag order is in a prior restraint, regardless of whether prior restraint jurisprudence applies. The court's task here is to balance intervener's First Amendment interests with Mr. Kohlberger's Sixth Amendment interests. Neither right is superior, and as a result, the court should aim to give both rights the maximum effect possible. It needs to protect the accused as fully as possible, and it needs to restrict publication as little as possible. The only way to satisfy those twin goals is to apply a standard that allows a gag order only when, 1, the prohibited speech is almost certain to materially prejudice a criminal defendant, and nothing else can prevent or cure the prejudice. All right. So anything less under reinforcing the First Amendment, a less demanding test will be over-inclusive, at times restricting protected speech that does not create prejudice, and that creates prejudice that can be remedied in other ways. The First Amendment will then be under-reinforced, as protected speech will be suppressed even if the speech does not infringe the criminal defendant's right to a fair trial. That outcome is intolerable because any First Amendment infringement that occurs with each passing day is irreparable. Number 6 says the gag order fails under strict scrutiny. Hey, Scott, how are you? Okay. All right, so a gag order survives a strict scrutiny only if the activity restrained poses either a clear and present danger or a serious and imminent threat to the protected competing interests. The order is narrowly drawn and less restrictive alternatives are not available. The gag order fails under each prong. First, there is no evidence that the speech at the issue poses a clear and present danger or a serious and imminent threat to Mr. Kohlberger's right to a fair trial. Hold on just one second, y'all. Okay, y'all. Okay, so it says that there's no indication that the individual subject to the gag order will disseminate the information that will prejudice Mr. Kohlberger. Law enforcement released limited information during its investigation. They really didn't release anything during the investigation. And after Mr. Kohlberger's arrest, including at the press conference announcing the arrest. As the prosecution moves forward, the party's attorneys must comply with the Idaho Rule of Professional Conduct 3.6, and the prosecution must comply with the Rule 3.8, even without the gag order. The party's attorneys' willingness to enter the stipulation suggests that they intend to strictly comply with those rules. So in any event, the gag order does not target prejudicial speech. It targets any speech concerning the case with no consideration of whether the speech would be prejudicial or helpful to Mr. Kohlberger. So at bottom, there is not a clear and present danger or a serious and imminent threat that, absent the gag order, publicity will prejudice Mr. Kohlberger's right to a fair trial. So second, as explained above, the gag order is not narrowly drawn. It is directed at a wide and vague group of people, and it governs any statement concerning the case, good or bad, for Mr. Kohlberger. The gag order does not narrowly target speech that could be most prejudicial, but rather wrongly assumes that all speech about the case is prejudicial. As a result, the sources of the newsworthy information have declined to provide information about topics like how the Moscow community is healing, how many cell phone towers are around where the murder occurred, the size of Mr. Kohlberger's cell, the meals that Mr. Kohlberger receives, and Mr. Kohlberger's job applications to the Pullman Police Department because of the gag order. Those topics of speech, while arguably subject to the gag order, are unlikely prejudice to Mr. Kohlberger, yet they are suppressed. Third, the parties have not explained why other less restrictive alternatives would not prevent or remedy any prejudice to Mr. Kohlberger. For example, prejudicial publicity can be mitigated by a change of venue, trial postponement, a searching voir dire, the emphatic jury instructions, and the sequestration of the jurors. So the need to consider less restrictive alternatives here at this early stage of the case is particularly acute. No trial has been scheduled. Probably won't be scheduled, y'all, for years, which is a damn shame. And given the seriousness of the charges, trial is likely more than years away. The parties in the court have ample time to assess whether unrestrained speech about Mr. Kohlberger and the facts and circumstances of the crimes with which he is charged unfairly prejudices his right to a fair trial. And if a danger emerges, there will be plenty of time to remedy it. Hey, Princess Megan, how are you? Okay, so it says number 7, the gag order fails under less exciting scrutiny. Okay, I'm just trying to catch up in chat and do this too, y'all. So courts that do not apply strict scrutiny to gag orders, like the one here, shall require some factual findings to support the gag order. So in Dow Jones, for example, the Second Circuit considered whether there is a reasonable likelihood that pretrial publicity would prejudice a fair trial, and exploration of whether other available remedies would effectively mitigate the prejudicial publicity. Other courts have required similar findings. Okay, this is all different cases right here. So there's on the end of it. Okay, so noting that after a full hearing where the press could be heard, the district court found evidence of the potential inability for an impaneling and impartial jury and concluded that there was no less restrictive means of safeguarding the defendant's Sixth Amendment right. A gag order must be no greater than the necessary to protect the interests involved. Hence, a gag order may be entered where there is a reasonable or serious threat. Less restrictive alternatives are not adequate, and the order would effectively prevent the threatened harm to the defendant's rights to the fair trial. See, a court may issue a participant gag order only where the press and the general public are given the opportunity to be heard to the questioning of the issuance of the order. The court describes those reasonable alternatives, and the court considered and rejected. The order is narrowly tailored to serve the interests of protecting the defendant's right to a fair trial, and the court has made a specific finding that there was a substantial probability in the defendant's right to a fair trial would be prejudiced by publicity that would occur on the absence of the gag order. So again, the parties here have offered no evidence of any risk of prejudice to Mr. Kohlberger or offered any explanation why alternatives to the gag order would not suffice. So far, there has been publicity surrounding Mr. Kohlberger's prosecution, but no indication that the publicity has been prejudicial. Since the murders occurred, law enforcement and now the attorneys have judiciously shared information with the public. There is no suggestion that anybody now subject to the gag order has previously made extrajudicial statements that may have biased the jury pool. In fact, Mr. Kohlberger may be less prejudiced if well-informed and responsible individuals share some information rather than allowing the gag order to create a vacuum of mere speculation on the internet. Because that's all that's happening right now. Everybody's throwing out all these rumors, and it can't be defended. They can't come out and say that is not true or anything like that. Candy, I think that they want out from under the gag order, the Gonsalveses do, because I think Mr. Gonsalves wants to speak. And there's no telling what he wants to speak about. But I think that that's what it is. And maybe he wants to clear up some rumors about something. All right, so it says, but even if there were some evidence of prejudicial publicity, there are other ways to ensure that Mr. Kohlberger has a fair trial. To start, his trial date has not even been set and will presumably occur well in the future. The passing of the time reduces the risk of any jury taint. Additionally, when the time for trial arrives, a change in venue, probing voir dire, a clear jury instruction can all ensure that Mr. Kohlberger has a fair trial. Some of that probably is true. I don't think it's going to calm down any until there's a conviction. And I think only then, once his sentencing and all that, he's in prison, I think then maybe it'll start calming down. I don't think it's going to until then, though. So at bottom, the gag order suppresses speech without any justification. That violates the First Amendment no matter the test applied. All right, so the gag order violates the Idaho Constitution for the same reasons. So courts have addressed simultaneously the First Amendment of the U.S. Constitution and Article 1, Section 9 of the Idaho Constitution, so that the court can find that the gag order violates the Idaho Constitution for the same reasons that it violates the U.S. Constitution. But the court needs not treat Idaho's Constitution in lockstep with the U.S. Constitution. If, for example, the court is persuaded that under federal law, gag orders need not survive strict scrutiny, it should consider whether they must do so under Article 1, Section 9 of the Idaho Constitution. Unlike the First Amendment, Article 1, Section 9 provides that a person may publish on all subjects. For the criminal trials, all subjects would include both information presented inside the courtroom and the information presented outside the courtroom. So as explained above, when balancing the right to speech with the right to a fair trial, the court's aim should be to recognize each right as much as possible. Only when speech necessarily infringes the right to a fair trial is there a justification for curtailing the speech. And again, strict scrutiny is an exacting standard that ensures speech is curtailed when and only when necessary. So even if some federal courts have interpreted the First Amendment to yield short of the outer boundaries of the right to a fair trial by adopting tests that are over-inclusive when curtailing speech, this court should interpret it, Article 1, Section 9, as more broadly protecting all speech that falls short of infringing the right to a fair trial, but either because there is not sufficient certainty that the speech will be prejudicial or because other remedies short of restricting speech can prevent or cure the prejudice. All right, y'all, we made it to the conclusion of it. So the conclusion is interveners request that the court vacate the gag order because it violates the U.S. Constitution and the Idaho Constitution. This was dated on May the 1st. Wendy J. Olson is the one who signed it. And it was sent to the Latah County Prosecutor's Office, which was William Thompson. It was sent to Ann Taylor, Jeff Knight, and also Shannon Gray. Thank you, white little baby. Y'all, they put too much stuff in all these documents. Good lord. Let's see. So, does everyone still suspect BK is a lone killer, or is there other suspect now? Candy, I still think that he had someone helping him. Okay. Okay, give me a second. You're welcome, King Scarlet. All right, I'm looking to see what else is on here. I don't know why it's taking so dang long to come up. Okay. I think he had help in some form. I'm still curious of who was driving the car that night because whoever was driving the car didn't act like they knew where they were at. Let's see. It's pretty obvious that the Gonzalez family is proactive with them finding video of the girls returning home at a certain time to counter the state's timeline. True, because the state was saying that they got home at like, what was it, 1:45? And thank you, White Widow Baby. And then Kaylee's sister, Olivia, actually found a video from the area and showed that they didn't get home until, I believe it was 1:52 or 1:56? Thank you, Gregory. And it's a shame that a victim's family has to go and figure out a timeline. Let's see. Our chat said, why wouldn't his dad question, why am I flying to Washington? Bonnie, I mean, I don't know. Like, is it just because? I mean, it would have made more sense to me that Brian would have just drove to the airport, left his car there, flew home for the holidays. They could have picked him up from the airport, and then he flew back. So I wonder if it was just like something that him and his dad did. Maybe his dad knew that he didn't like that Brian didn't like flying, but he didn't really want him to drive cross country by himself. Let's see. Do you believe that they have continued this and want the gag order lifted to talk about stuff like possible findings into Little Liar and other info that they have uncovered? Um, I mean, as a possibility, I'd, I'm gonna say, in my opinion, I think that maybe he wants to talk to clear up some rumors, and it could have something to do with Brian's attorneys. I don't know. I don't know if the Gonzalez family's attorney would allow them to talk about that or about Ann Taylor. Um, but possibly some rumors that's going around. Because right now the internet is running rampant with some rumors, y'all. Carmack, no. I love you all dearly, but I am not reading that thing over again. Sorry. See, he knows that he was being let go from. Yeah, I'm sure he did. Now, I still don't know if the whole the letter that they had showed that where he was being let go or whatever. I still don't know if that's legit. Only because it wasn't. We didn't see it be put out by um, WSU. You always thought the DoorDash was delivered around the same time as the killings extremely fishy. Yeah, Candy, they said that DoorDash was delivered at 4 o'clock, and then the last time the car was seen going to the house was at like 4:04, and then it was seen leaving the house at 4:20. Let's see, Scarlett. I am wondering if one of the IDs found in Brian's glove box belonged to Bethany, which is why the defense has petitioned her testimony. I don't know, Gregory, but a lot of people are thinking that maybe it was Bethany's. that made, there's a rumor going around that Bethany and Brian were dating. I've even said y'all are gonna look if it comes out and it's Bethany is his alibi. Um, but then again, that's another rumor that we don't know for sure if it's anybody else's ID other than Brian's. So the family was pushing the petition to get her removed from the case. Yes, they were. They actually on their the Facebook group that they have, the Gonzalez family has, they had posted the petition on there to have her removed from the case and was asking everybody to sign it. Okay, let me look and see if there's anything else on here that we haven't looked at. Hold on just a second. Okay, y'all. Let's see. Bethany. Bethany is way out of this league. I think, honestly, I think all the girls were. Okay, devil's advocate. Why would they need an ID to think of interviewing her? Wouldn't Brian just say, I hung out with Bethany? That is true too, Stevie. But I mean, that once again, that's just a rumor that was going around. It was almost like Banfield sources went back through the court documents and like the stuff that they found on the search warrants, on the warrant returns or whatever, and was like, oh, here's something we can make up a rumor about. And they find the IDs that they found in a glove in a box. And they decide to make up a rumor about it because they know, like I said, there's a gag order. So you can't, like, nobody's going to come out and defend it and say, no, that's not true. That's not, it was not one of the victim's IDs or anything like that. And that's the same thing with the video going around of the, was it the Jack in a Box thing where they're talking about the DoorDash driver or whatever? Anybody can say anything and make up a whole big, huge lie. And there are some people out there that will hear it and then run with it as it being truth when there's absolutely no proof that it's true or not. So we should get Kim to go on Banfield. Okay, wait. We should get Kim to go on Banfield and we can get all the drama off YouTube. Okay. Let's see. I think he was probably doing a date that night. No surprise. Like him getting fired. We really don't. That is true, P Fox. I mean, he's. Where did I see that at? There was somewhere. I don't remember where it was. I saw it, but it said there was one of the. I want to say one of the professors that Brian worked with while he was at WSU said, or somebody within WSU that had said that he is no longer a student and no longer employed. But the whole letter thing that came out, we don't know if that's true or not. We don't know if that's a legit letter from WSU. Let's see. What the family getting calls about Kay being dead hours before the 911 call. Maybe they have researched that aspect and want something out about it. I mean, I don't know. It seems like that there's something that they want to talk about. And whatever it is, like they are pushing to get out from under this gag order. Okay, give me a second. Let me go through this last one real quick and see if there's any significance to it. I don't think there is. Okay, so now the last thing that they have on here is just it's wait, what is this? A notice of appearance, and it just names all of the companies that's within the media coalition. Like I said, there's like 30 of them. Okay, so that's really all there is as far as the court documents. Okay. Roger, have I said hi to you tonight? Jen Koff said that the other night that the one motion was definitely not about the gag order. Then, bam, she stubbed her toe big time. Oh, Roger, I know. Yeah, I remember that. And there was another attorney. Uh, what is her name? Sarah something. I forgot Sarah's last name. But she was actually on with Brian Inton. Sarah was and Jennifer Coffindoffer that night, and the Sarah lady kept saying uh, that it more than likely has something to do with the gag order. And Jennifer Coffindoffer was like, no, it's something else or whatever. And then come to find out, it was about the gag order. And then Jennifer Coffindoffer wants to put out a tweet that was like, okay, so that's what it was about. So everybody was wrong. And technically, no, only she was, because she was the one screaming it was about something else. Okay, let's see, just got here. Well, Roger, thank you for joining us. And how are you tonight? Okay, let me jump back into my email real quick, y'all. And see what else I got in here. Let's see. Hold on just a second. All right. Maybe Dylan and Bethany were both at separate dates. Bonnie, you mean like they were both dating BK? Is that what you're saying? I mean, who in here thinks that? Put a one in the chat if you think that Brian was dating either one, either Bethany or Dylan, and put a two if y'all don't think that he was. I just want to see what everybody thinks about that. Okay. Hey, Dub, how are you? Okay, so everybody thinks no. Okay. Jessica Lynn, how are you? Hey, Sheila. 2, they weren't that hard up. Wait, Stevie, you think that he was dating one of them? See, Danielle says 2. Hey, Glowbug, how are you? Brian, did you put a 1 or 2 in the chat? Brian, you didn't even vote. Login again. Okay, Gigi. And Glowbug, I'm doing good, thank you. All right, so pretty much everybody thinks that there was nothing going on between him and Bethany or him and Dylan. I don't like. I wonder what they're claiming that was the exculpatory evidence that Bethany had. So yeah, let's see. I'd say that he was tutoring one of them way before dating. Okay. I mean, that could have been possible too, though, P. Fox. I didn't even think about the whole tutoring thing. 1, 2, anything could be possible in this case. Who knows? Yeah, but Troll, you got to pick either a 1 or a 2. Brooklyn, how are you? DoorDash driver is gonna think, well, I better pay attention to the white sedan driving. So I try the car connection, the biggest mess. Let's see. Global Legacy 1.5. I'm just speculating. But, I mean, P. Fox, now that is a good speculation because Kohlberger's supposed to be like this smart dude. Maybe Bethany or Dylan, either one, might have needed help in some of their work. I mean, do we know that he didn't put out like an ad to tutor people? Maybe he did that to try to, for that to be a way to meet people. Let's see. Wonder why they want her off the case. Wait, Dreamcatcher, who are we talking about? Let's see. TAs don't make that much. I mean, it's a good thing though, P Fox. What you were saying. I mean, it could be. I mean, it could be a possibility. He needed extra money. Uh, he had the time. A good way to meet people. Let's see. Can I change to 1 and 2? That way, I'm right either way. Oh my God, they will have Brian dating Ann next. I don't know. I just don't know if him and Ann are gonna get along too good. I mean, they might right now. Hey Heather, how are you? Just because they're not around each other a whole lot, but just wait till the trial gets here or the prelim, and then every day sitting in court in trial. I'm crazy. Oh, y'all can't forget about Stevie too, though. I think Stevie had hots for her as well. Okay, let me grab my next thing here real quick. More rumors in this case I've ever seen. It's like every day you turn on YouTube and there's something new to hear about. She was tired and cold. It was for order. Wait, Brian, what was $475 order? Maybe it was cheeseburger for in the morning in a dangerous neighborhood. Oh, he's talking about DoorDash, y'all. See, didn't you say they wanted Bethany off the case? No, Dreamcatcher, we were talking about the Gonzalez family wanting Ann Taylor off the case. Because the Gonzalez family, the petition that was going around to get Ann off the case, the Gonzalez family was posting it on their Facebook group, asking people to sign it. Let's see. BK would have had an endorphin at high if he would have been able to date. If he would have been on a date with Bethany, he would have been pondering the possibilities of getting some of that and not in a rage. But I wonder what it is though that like. There's got to be something though that they're claiming as exculpatory. I mean, what other could it be other than her being his alibi? Must have got lost. Thank you so much for being a member for 4 months. See, and they said, "Hey, all working but listening. Much love to all." Well, much love to you as well. Must have got lost. And Dreamcatcher, that's fine, honey. No need to apologize. Let's see. There was help assisting. Bonnie, I agree. I think that maybe not what happened inside the house, which there could have been help there too. But I have always said that I think if somebody else was driving the car and that he might have had help possibly planing it. Let's see. One creator who will remain nameless said DM probably bought weirdo BK home from her. Oh, wow. I'm not even going to ask P Fox who even said that. Like some people, that's what I'm talking about. Just the crazy rumors that people will say. And there, some creators have a loyal following to the point that if they said that Brian Kohlberger was hanging upside down in a tree in the backyard, they would run with it because their creators said it. They would run with it and state it as a fact. Let's see. I got those vibes from the Enon Harsh dude. Oh, Candy, that's a creepy neighbor. Let's see. Wait, yeah. Yeah. I know who gave you 11 guesses. Oh, that's who said it, P Fox. See, that's what I'm saying. That I mean, there's absolutely no proof that either one of those girls, Bethany or Dylan, either one had a sex job of any kind. Now, I do question why it took 8 hours to call 911 after she's seen this dude in the house that late at night. But to sit here and say something like that is completely disrespectful. Seriously. There's absolutely no proof of that. Let's see. We're spot on. Thank you, Heather. I'm just trying to catch back up here real quick. Let's see. I mean, just the shit that she was saying that night when she was on my panel about what was on the boys' phone out in the band field is ridiculous. He likes trolling. Brian Hoffman. You know them ain't batons. Those are fire sticks. That's like his hobby. Saw hearing balls and was alarmed she hasn't been doing no sex work. I don't believe. I'm gonna be honest. I don't believe that her or Dylan, either one, were doing anything like that. And even if they were, there's absolutely no proof that they were. So why are people like making shit up and running with it? And especially to say something like that. I mean, you can speculate and you can give your opinions on stuff, and you know, throw out your theories and all this and that. It's fine to do that. But when you start saying something like that and then you put it out as a fact, it's not right. Like all of these different rumors that are going on, it's ridiculous. Even if there were, it's none of anyone's business. And Glowbug, that is true. I mean, it's nobody's business. Why put it out? That's the same thing as old Twitter dude over there. I forgot what his name is. And the shit that he was saying about Dylan. Right is right and wrong is wrong. Whether you agree with Dylan waiting at 7.5 to 8 hours to call 911 or call somebody to the house or whatever, whether you agree with that or not, right is right and wrong is wrong. And what people have said about her and the stuff that she does with her life is wrong. Are making up lies and rumors. Hey, Crime Solver, how are you? Are making up lies and rumors like Twitter dude was making up when you have no facts of it at all. Let's see, as a creator, it is irresponsible to spew such shit. That is true. Because I mean, there are people out there, like I said, who have a loyal following. If that creator got up there and said Brian Kohlberger was seen hanging upside down in the backyard from a tree, people would run with it. No matter how crazy it is, there are people that would run with it. Okay, so let me see what else I've got sitting in my inbox for tonight. Because there are a few different cases that I wanted to catch y'all up on. All right, so you know the Texas one real quick. I'm gonna jump onto the Francisco Oropeza that shot the 5 people in Texas. They did catch him. Glowbug this. That is true. Okay, I'm just catching up real quick. Okay, I'm looking through my thing. I'm trying to get the Francisco Oropeza article pulled up here real quick. But I mean, and creators need to realize that there are creators who are being sued right now for shit that they are spewing, for making up rumors about people. Slandering people's name and defaming their character and all that. I mean, that's... let's see, the rumors are getting worse with every day that passes. Is so disrespectful to the victims and their family. Danielle, I agree. It's literally every day when you turn on the TV, there's a new rumor. Okay, well, let me see if this is... Okay, so the Oropeza dude was arrested. I don't know if y'all remember Monday when they got a phone call and said that they seen him, and all law enforcement took off running, driving down to I forgot the little town, but it wasn't very far from where the shooting happened, and then they ended up not getting him. They had to lock down the schools and everything. Well, they did say today that was really him. They just lost track of him. And then yesterday, somebody called in a tip and said that he was at a house. Told him where the house was at. Within 90 minutes, they had him sitting in handcuffs. And they actually found him in a closet underneath a pile of dirty laundry. And now they have also arrested his wife or domestic partner. I don't know if they're really married or not, but they have arrested her. And there's some other people. I think it was him and 4 others total that were arrested. Okay, so it says Francisco Oropeza, Texas shooting suspect captured after tip-off. So Francisco Oropeza was detained north of Houston. He was several miles from his home where the shooting happened late Friday. Mr. Oropeza is accused of attacking his neighbors after they allegedly asked him to stop practicing with his rifle as the noise was keeping the baby awake. And this baby was only like a month or 2 old. That they were trying to get to sleep and couldn't go to sleep because he was out shooting his gun. So the victims included a 9-year-old, which was the little Daniel boy. So they were all from Honduras, and the country's foreign minister identified them as Sonia Guzman, 28, Diane Velasquez, 21, Abdulia Molina, 31, Jonathan Cazares, 18, and Daniel Lasso, who was 9. So the arrest of Mr. Oropeza, a 38-year-old Mexican national, brings to an end a 4-day manhunt that swept up law enforcement officials across multiple jurisdictions, including the FBI. Drones and scent tracking dogs were used as police searched an area as far south as the Mexican border. Now, I did hear, was it yesterday morning or the night before that, and this was before they caught him, that they actually had law enforcement that had already crossed the border and was down in Mexico looking for him. So it says authorities offered a reward of $80,000 for information leading to his arrest, and on Tuesday, the FBI said that Mr. Oropeza could be anywhere as a days-long search failed to yield any leads. But a member of the public contacted the FBI's tip line on Tuesday evening, and the suspect was captured just over an hour later near the town of Cut and Shoot, officials said in a news conference. Police have not said who owns the home that he was arrested in, but the New York Times reported that the property records show that it belongs to a relative. I heard that it was his aunt. Yes, Candy, he is. He's actually been deported. To begin with, they said twice. He's actually been deported 4 different times. All right, so they can rest easy now because he is behind bars, Sheriff Greg Capper said of the families of the victims. He will live out the rest of his life behind bars for killing those 5. Let's see. Were the victims in his country legally? No, Gregory. I think the only one that lived in the house where the murders happened with the Honduras family, the only one that was here legally, I believe, was the baby. Like I said, a month or 2 old baby. All the rest of them were here legally as well. And like I said, I don't agree with people being here illegally. If you want to come to America, you need to do it the legal way and go through the whole process of becoming a United States citizen. But that doesn't give this Oropeza guy the right to go over there and kill them just because they asked him to please stop shooting his gun because their baby was trying to go to sleep. Gregory, you're welcome. Candy, I mean, it's getting ridiculous, honestly. Like I said, this guy has been deported 4 times. Okay, so it says the suspect was taken into custody by members of the Border Patrol Tactical Unit, or BORTAC, a specialized unit, said Sheriff Cappers of San Jacinto County. He will be charged with 5 counts of murder. The alleged attacker was deported 4 times between 2009 and 2016, U.S. immigration officials have said, although it is unclear on what grounds this happened. An investigation is underway into how the suspect obtained the weapons and used in the killing, which was an AR-style rifle. On Wednesday, police said that Mr. Oropeza's wife, who also had been arrested. Dava Mora Lamar Nava, 53, was detained in connection with the Friday night shooting in the small town of Cleveland. Montgomery County Sheriff Rand Henderson said that she allegedly hid Mr. Oropesa before he was captured by police. She faces a felony charge of hindering the apprehension or prosecution of a known criminal. So also on Wednesday, officials said that Mr. Oropesa was spotted in Montgomery County, where he was later arrested on Monday afternoon, but managed to evade capture, which is the day that they had to lock down all the schools and all that. Let's see, he was still in America to serve his time out. All right. Angie, yes. He will actually, more than likely, he'll get the death penalty. So we did confirm that was him on foot running, but we lost track of him. That was not a false alarm. That was him, Sheriff Deputy Tim Keene said. A makeshift memorial with floral tributes, balloons, and soft toys have been placed outside the home where the shootings took place. And that is the father. He's actually the guy that went over and asked the neighbor if he would stop shooting his gun. And it was his wife and stepson, the 9-year-old little boy, who were murdered. Okay. I mean, they had said that the wife had actually been in constant contact with law enforcement, which she was probably trying to keep up with what they knew, because she knew exactly where he was at the whole time. And I got another, let's see this one right here. I got another article that tells a little bit more about it. So let me grab it real quick. Yeah, he's going to end up getting a death penalty for this. And I'd also heard that they bumped up his, hey, One Juror Matters, how are you? His bond from $5 million up to $7.5 million. But the DA was asked why they did that, and basically all he really said was because he's more than likely a flight risk, and that's why they bumped it up. His wife, though, or domestic partner, whatever she is, I wrote hers down. I think hers is like $250,000. Yeah, the wife has got a $250,000 bond. All right, so let me pull this up for y'all real quick. There's been, see, this happened the other day. Then we had the shootings that happened in Oklahoma on Sunday, which is another crazy case. And then today had the mass shooting in Atlanta. Yeah, Candy, the 9-year-old was the youngest out of the 5 that was murdered. It was him and his mom. And then there was an 18-year-old, a 25-year-old, a 21-year-old, and a 31-year-old. Let's see, the wife could have made $80,000, got rid of a killer, and been free. Yeah. And see, they had even yesterday, before he was caught, the U.S. Marshals added $20,000 more dollars to the reward money and bumped it up to $100,000. So it's almost like as soon as they did that, that's when the tip came in of where he was at. See, what is making people go nutty lately? I feel like either false flags are going on or something is in the dang. Candy, it's got to be like something in the water. I don't know what's up with people. All right, so this one says multiple arrests, including woman believed to be suspect's wife, have been made in the San Jacinto County shooting. So multiple arrests have been made in connection with the mass shooting in Cleveland, Texas, according to officials with the San Jacinto County Sheriff's Office. Deputy Sheriff Tim Keene said that he could not confirm how many people and who were arrested, but at least one woman who was believed to be Francisco Orpiz's domestic partner, uh, Divamira Lamar Nava, was also arrested and charged with third-degree felony for hindering apprehension of a known felon. Her bond has been set at $250,000. So multiple pieces of evidence was recovered at the home where Oropesa was found, officials said. Hey, Pickle Me Elmo. Let's see his vaccines. Okay, Ultra. I don't know, y'all. It's something. Like, it's something going on. Okay, so it says, at this point, the only way for that to go any higher, and they're talking about her bonds going any higher than $250,000, would be that if she was named as a party to the offense and there's no evidence that she gave him any material aid or encouragement in committing the offense, talking about him going over and doing the shooting at the neighbor's house. So that came from the San Jacinto County District Attorney Todd Dillon. So it's likely to state as a third-degree felony. Keene said that more arrests are likely. Francisco Oropesa was apprehended on Tuesday evening after a 4-day manhunt. So Oropesa is expected to be charged with 5 counts of murder, and his bond is also expected to be set at $5 million. I wonder if Vapor, all of them were except for, I believe, the baby, the youngest. Like, I think they said the baby was either a month or 2 old. The one that they were trying to get to sleep that night when he kept shooting. But yeah, all the rest of them were here illegally. And I know that the Honduran consulate in Houston they're working with the family to get the 5 victims, their bodies sent back to Honduras. And they have also said that they demand, and this comes from the people down in Honduras, the government down there, that they demand that the man be caught. And this was before he was captured yesterday, but that they demanded that he be arrested and feel the full weight of the law. And I know that there was some journalists that had went down to Honduras and talked to some of the victims' family members. Okay, so it says Oropesa was found in a home in Cut and Shoot, Texas, hiding in a closet under a pile of laundry. Keene said that he didn't resist, probably because there was a canine dog present. He wasn't there the whole 4 days, Keene said during an early morning press conference on Wednesday. Can't say when he arrived. We think we know how he got there, but we have to prove that out. Keene said that Oropesa also had a cell phone. His original phone was found near the crime scene. And Keene said that it is believed that he was able to get another one from someone else. Not everyone who was arrested was in the house. One was close by. So it was also said that there was an acquaintance of his that was arrested on marijuana charges. And there's going to be some other charges as well added to that one. See, I'm saying I wonder if all the people arrested were illegals. I don't know, because they haven't even give out who it was other than his wife, domestic partner. I mean, some places are calling her his wife and some are calling domestic partner. So I don't even know if they're really married. Okay, so he added that everyone Oropesa had been in contact with was in the area and never left. I believe that he thought that he was in a safe spot, Keene said. Keene also said that the tips received on Monday, which prompted the lockdown at nearby schools, when it was said that he was believed to be near a landfill, were indeed the sightings of Oropesa. We did confirm that it was him on foot running, but we lost track of him, Keene said. That was not a false alarm when the schools got locked down. It was that event. Keene also addressed the response time to the officers, or for the officers to arrive to the crime scene on Friday, because they were talking about how long it took them to get there. And they only had, I believe it was said, like 2 officers working that night. Put a reminder, be kind to one another. Make sure you laugh, smile, perform. Okay. One juror matters. Have a good night. Okay, let me get back to this now. It says, if any of you guys have been to the scene where the house is, to go from the sheriff's office to there, lights and siren, we're talking at least 30 minutes. This is not a rich county. We've got 3 deputies on patrol to cover this entire county. If you're going from North County to where the shooting occurred, it's an hour drive with lights and sirens. So why, if it's that big and it takes that long, why the hell do they only have 3 officers? Okay, give me a second, y'all. Okay, so they're also blaming it on poor roads. We're understaffed, and welcome to the rural law enforcement. Y'all, the parish that we live in is a pretty big, good sized parish. We have the parish sheriff department here. We live out in the middle of the sticks, and our parish has the worst roads probably in the state of Louisiana. And it doesn't take an officer to get, it doesn't take them the 30 minutes like they're claiming. I mean, that's a little bit ridiculous. If they don't have it 3 officers, they need to hire some more people. Okay, so it says our response time really was, I didn't have the exact number, around 14 minutes. For that area, that's excellent. There was another patrol unit on an aggravated robbery call, and they had to leave that call, which is a serious call. So Keene said that they received the calls from the neighbors about Oropesa shooting in the yard, but at the time, it was the aggravated robbery call trumped the shooting in the yard. So at that point, it wasn't an attack. See, that other call escalated, he said, and we were doing what we could with what we had. It's crazy. I mean, get more people. All right, I got to check my email real quick, y'all. So, and I had also heard that he was at that house, which they're saying was his aunt's house, where he was arrested at. But that his wife, domestic partner, whatever, had gotten a message to his cousin, to Oropesa's cousin, about coming to pick him up and get him down into Mexico. And I think that that's probably what he was waiting on, is for someone, family member, friend, whatever, to come pick him up and take him back to Mexico. Okay, wait. Let's see. Whom was the letter to, explaining what? What are we talking about, a letter? Let me pull this video up. I need to see what it is real quick. If y'all haven't done so, please hit the thumbs up. 20 miles from the house of the shooting, I think. Yeah. I mean, and they're claiming they think they know how he got there. They just got a proof of how he got there. More than likely, he hadn't. I mean, he dumped the one phone, and they found it. He probably had a burner phone. Called somebody to come pick him up, and that's how he got there. And I mean, the wife knew that he was there. Okay, give me a second because I have a video that I'm about to play regarding this case. I just got to get the video pulled up. Okay. Let's see, I do think it's odd that it would place it right. Okay. 2 seconds, y'all. I'm just trying to get all of my stuff. Okay, let me see if I can get it pulled up here for y'all now. Three banks. Who are y'all talking about that has all these bank accounts? Okay. Now, hopefully this will be y'all be able to hear it. So whenever I start playing it, just give me a thumbs up in the chat so I'll know that y'all can hear everything okay.
Tonight, new information about the man accused of killing 5 people in San Jacinto County.
We're also learning more about his wife, who is charged with helping him hide. Grace White is at the San Jacinto County Jail with the new details she's uncovered about the case. Grace?
Francisco Oropeza's next stop is a grand jury. It could be a month or more before he's in court because investigators still have to gather all of the evidence. Meantime, records we obtained show he was found at an address investigators have had on their radar since last summer.
Yes, this could end up as a capital murder.
The San Jacinto County District Attorney's Office says they are considering all options, including the death penalty, as they prosecute the case against Francisco Oropeza.
You are charged with hindering the apprehension of a fugitive.
Oropeza's wife, Divimara Nava, is also in custody. In a hearing, prosecutors told the judge she admitted to asking Oropeza's family for help getting him to Mexico, but they turned him down. She also gave up a timeline, saying Oropeza got to his aunt's house in Montgomery County the day he was arrested at 1:30 a.m. She says he showered, slept, and she went to get him donuts.
That was an early address that was provided to our analysts as a target.
And we now know why. KQ11 obtained a copy of a protective order Oropeza's wife filed against him last summer. Prosecutors say she claimed Oropeza beat her up. The protective order says he had to move out, could not have a gun, or pick up their child from school. But the problem was they could never find him.
The constable made several attempts over the course of weeks to make contact with him and was not able to make contact with Mr. Oropeza.
Government records show Oropeza has been deported 4 times and has a previous DWI conviction in Montgomery County. In the Cleveland killings, the DA's office says anyone who helped hide him is fair game for arrest.
That if you hide a fugitive, especially somebody as violent as this, and we can prove that you did it, you will face the consequences.
There is a third person in custody. He was arrested for drugs, but we're told they could upgrade his charges if investigators determine he helped Oropeza hide. In San Jacinto County, Grace White, KHOU 11 News.
And now that Oropeza is in custody, today his neighbors are telling us they are relieved because they can now let their kids play outside. One man telling our Aniela Ruiz, Oropeza had been feuding with the neighbors he's accused of shooting over their dog getting into his yard.
Pancho me platicó que creo que el perro le había matado las gallinas en su propiedad y él le fue a decir que amarrara a ese perro.
Neighbors say that combative relationship, no excuse for the shooting, and they want Oropeza, referred to as Pancho here, to pay for what he allegedly did.
We have also heard concerns from neighbors about how long it took for San Jacinto County deputies to respond to the shooting call. The deputy chief gave us new insight about that today.
If any of you guys been to the scene where the house is, all right, you know what kind of roads those are. To go from here to there, lights and siren, we're talking at least 30 minutes. This is not a rich county. We've got 3 deputies on patrol to cover this entire county. There was a other patrol unit on an aggravated robbery call, and they had to leave the aggravated robbery call, which is a serious call, all right? And so you've got 2 bad things going on at once with one deputy to do it all. You got to remember the initial call on this was somebody firing their gun in the yard. At that point, it wasn't an attack. So the aggravated robbery trumps the guy shooting in the yard at the time.
The San Jacinto County Sheriff's Office says they do appreciate all the help they have received during the manhunt.
We want to take a moment now to remember the people who lost their lives in this tragedy. 21-year-old Diana Velasquez, 28-year-old Sonia Guzman, 9-year-old Daniel Enrique Lazo, 31-year-old Abdulia Molina, and 18-year-old Jonathan Caceres.
Right now, you can watch and read even more about the events surrounding the capture of Oropeza, the arrest also made. And of course, remember those victims. So many are mourning now. It's all on KHOU.com, and it's also on the KHOU 11 app.
Okay. Damn, she admitted to everything. The wife did. Gave the timeline of what happened when he got there. Admitted to even trying to get him out of the country. Oh, see, the next time he gets deported, yes, it will be in a box. I'm writing down the timeline. So I wonder if it was one of his family members that turned him in, because they said that she admitted to getting in touch with some of his family members to try to get him into Mexico, and they turned her down. See, the wife is not too bright. I agree, King Scarlet. She's really not. So, I mean, if she's found guilty of her crime, there's no telling how long she's going to be in prison for now. I mean, she gave every little detail, even down to going and getting a man some donuts, y'all. Let me catch up here real quick. Okay, I know I probably missed a lot of comments. Let's see, no surprisers, I like Peter too. I mean, she literally had a protection order against him. Why would she try to, like somebody said, why not turn him in? If you know where he's at, turn him in and get the reward money, instead of trying to help him and getting yourself in trouble and thrown in jail and possibly going to prison. See, I'm wondering if there's a stipulation if you call to claim the money, but then you're actually charged with a crime, do they not have to pay? Probably not, K-Braz. I doubt that they would give the money at that point. If you got arrested, they would probably turn around and, I don't know, maybe do a charity or something like that. Give it to a charity or something like that. I don't know. I don't know how that works. Okay, let's see. The money maker, your kids might die. Oh Lord, I don't even know what y'all are talking about. Okay. All right. Let's see. What's the next one? All right. Let me grab this one about the guy that we were talking about last night. That he had killed the 6 people. It was his wife, her 3 kids, and 2 of her kids' friends. I don't know if you saw my statement. I wasn't asking if the people killed were legal. Asking if all the people arrested. Oh yeah, Vapor, I saw the question. I don't know. The only person that they have mentioned other than him that was arrested was the domestic partner or wife or whatever she is. And they didn't say like if she was here illegally or what. The other person that they were saying that got arrested, they didn't mention anything on like their immigration status or anything like that either. So I don't know. I've heard that there's him, like 4 people total, but he's the only one that they've said that was here illegally. So I'm hoping with like the next few days, they'll come out with more information on the rest of them. because I don't even know if the wife is even. They never said if she was a U.S. citizen or she was a Mexican national or what she was. All right, I'm about to pull up. Let's see. All right, so this murders that happened in Oklahoma has turned out to be a crazy case. See, I'm needing to get some sleep. Thanks, Candy. You have a wonderful night, and thank you for stopping by. So anyway, that has turned out to be a crazy case. I had listened to the mom who was murdered, her mama, and her aunt were on Banfield. And none knew about this Jesse McFadden, like his past or whatever. And the mom said that her husband was looking into Danielle, have a good night. That her husband was looking into somebody that he worked with, trying to find out what his charges were or whatever. And they found the Jesse McFadden dude on the RSO list. So they asked their daughter about him. She claims the daughter who was murdered, she told her parents that it was a complete misunderstanding. The Jesse guy had actually hired a woman to pretend like she was a victim of his and told the wife that it was a whole big misunderstanding. The whole thing was. And so she believed him. She thought it was a big misunderstanding. The grandmother said that he was very controlling, that if the kids come to their house, he tracked them everywhere they went. The kids really couldn't have anything to do with the grandparents. The mom couldn't have anything to do with her parents unless it was some kind of school thing that the kids had. I believe the kids ran track and all that. The other two girls, Ivy and Brittany, their parents knew nothing about his background at all. And then Banfield also did an interview with the youngest daughter of the woman who was killed, her dad. And he had no idea of this Jesse guy's background. Okay, so let me pull this up now. All right. So it says he was a convicted SO. He fatally shot 6 people in Oklahoma, then himself. So it says, and I have to be careful with the words that I use on here, so you'll have to bear with me. So you can. So it says a convicted SO shot 6 people in the head and then himself, an Oklahoma police chief said on Wednesday. The Okmulgee police chief, Joe Prentice, said that the victims also sustained between 1 to 3 rounds in the head. And we need a trigger warning. Hold on, let me put the trigger warning in here. Okay. So it says after he murdered them, he then unalived himself. The evidence is that Jesse McFadden murdered 6 people, then he unalived himself. Beyond that, I don't know what his thought process was, Prentice said. I'm not going to express a theory because I follow the evidence and I don't have any evidence about what the motive was. From what I gather, the motive was he didn't want to go back to prison because of what his trial that was supposed to start Monday, and he even blamed that on the girl who was a victim that was supposed to be testifying against him in that trial. He literally sent her text messages saying that because she kept it going, the whole trial process and the legal process behind what he did, it was her fault that he did what he did, which is absolutely not true. So it says the six victims were identified as Ivy Webster, Brittany Brewer, Riley Allen, Tiffany Guess, and Michael Mayo, and Holly McFadden. Now, Tiffany Guess, that's the girl. Her dad is the one that I was talking about a minute ago that did the interview with Banfield. So authorities began a search after Jesse McFadden failed to appear at his long delayed jury trial on Monday in Muskogee County. The victims included his wife, her son and daughters, and 2 teens who were visiting the family over the weekend. Authorities discovered the victims Monday after going out to the McFadden property, which is located near the city of Henrietta, about 90 miles east of Oklahoma City. The bodies of Webster, Brewer, and Allen were found separately about 150 yards from each other, Prentice said in a news conference, and about a quarter of a mile from the McFadden residence. Bonnie, have a good night. Prentice said that the other 4 bodies were discovered together about 450 yards from the other 3 victims. The weapon used in the shooting was a 9mm handgun purchased by Jesse McFadden's wife, Holly, in January of 2022, Prentice said. The shooting happened as a series of ominous text messages sent by McFadden to his young accuser hours before his trial was to begin on felony charges of soliciting and processing images of child SA, suggested that he blamed the woman for ending his great life and that he was determined not to return to prison. So according to the screen grabs of the messages forwarded by KOKI TV in Tulsa by the now 23-year-old woman McFadden allegedly groomed from prison, he says that he was having success at a marketing job and making great money. Now it's all gone, he texted. I told you that I wouldn't go back. This is all on you for continuing this, he finished. A solicitation conviction can mean a 10-year sentence, and the pornography charge could mean 20 years behind bars. He blamed it all on her, which is typical narcissism. It's not her fault that he did what he did while he was in prison for R-ing somebody. So the Muskogee County District Attorney Larry Edwards said that the young woman shared the text messages with him as well. Now family members of the victims are asking why McFadden, sentenced to 20 years in 2003 for first-degree R and an SA of a 17-year-old, was freed 3 years early in part for good behavior. Vapor, thank you so much for gifting those memberships. That was very nice. So they let him out 3 years early for good behavior, despite the fact that he was facing new charges that he used a contraband cell phone in 2006 to trade nude photos with a woman who was then 16, which is this woman that he sent the text to a few days ago. He was released in 2020 after 16 years and 9 months, even though the charges could send him back to prison for many years if convicted. So as they rushed him out of prison though, but how? Asked Janet Mayo, which is Holly McFadden's mother. She said that she was told that her daughter and her grandchildren, Riley Elizabeth Allen, 17, Michael James Mayo, 15, and Tiffany Dora Guess, 13, were all shot to death. So Oklahoma failed to protect the families, and because of that, my children, my daughter, and my grandchildren are all gone, Mayo told the Associated Press. I've lost my daughter and my grandchildren, and I'm never going to see them, never going to get to hold them, and it's killing me. Which is a whole sad thing. He literally committed these crimes while he was in prison. Okay. What he was convicted for and serving that sentence for, he was doing again. While in prison, he gets charged for it. They let him out. And then a month later, he gets arrested again, but he bonds out on it. They should have never let him out to begin with. They should have never allowed him to get out early just because of good behavior. Like, that should have been something that he had to have served out his full sentence. Okay. So Justin Webster, who said that he allowed his 14-year-old Ivy Webster to join a sleepover at the McFadden home, not knowing anything about the man's past. Troll, thank you for gifting those 5 memberships. Raised similar concerns about McFadden's release. To get to save some other children, to make a change is what I want to do, Webster told the AP during a tearful interview today in Henrietta, expressing a determination to tell Ivy's story and our story, and to get our government officials and everybody to start speaking up aloud and keep those pedophiles in jail. He should have never been let out, honestly. It's ridiculous that they would let someone with those type of charges out of jail, especially out of jail early. So there needs to be repercussions, and somebody needs to be held accountable. They let a monster out. They did this, Webster said. A spokesperson or spokeswoman for the Oklahoma Department of Corrections did not immediately respond to the request for comment Wednesday on why McFadden was released despite facing new felony charges. Prosecutors objected to any early release from the prison, noting that he tied a 17-year-old's hands and feet to a bedpost, cut off her shirt, and arred her at knife point. And at one point, he threatened to use a knife on her if she did not shut up. And this is what he did to somebody. And they let this man out. Like, that makes absolutely no sense whatsoever. So the circumstances have alarmed Republican State Justin Humphrey, who's chair his chamber's Criminal Judiciary Committee. He told the AP that in a text that he's working with another lawmaker on legislation that would stop tragedies of this nature from occurring again. I mean, honestly, it should have never occurred to begin with. They should have never let the damn man out of jail. On the other hand, they probably could have done a search. See, Roger, that's what the grandmother is saying. That they found the Jesse guy. For whatever reason, her husband was looking for someone else and some charges that he had, and he ended up finding the Jesse guy on that list. Stella B, how are you? So he said that the effort also will involve trying to determine how a person could commit those type of crimes in prison and be released on good behavior, and how McFadden was able to be in contact with minors while on SO supervision. Wait, let's see. Yeah, if we could get Little Liar in here, she could learn something. So court records show that McFadden was charged with a new crime in 2017 after the young woman's relative alerted authorities. Set free in October of 2020, he was arrested the next month and then released on a $25,000 bond pending the trial. He was charged in 2017 while he was in prison, let out of prison in 2020, and then arrested again in November 2020. And then was let out of jail on a $25,000 bond. How the hell was his bond that low? Okay, so it was pending the trial, which was repeatedly delayed in part due to the pandemic. Let's see, where did they accepted the explanation of mistake or whatever it was and just moved on, if I'm understanding correctly. All right, let me get back to this. All right, so McFadden married Holly Getz in May of 2022. So they wasn't even married a year when this happened, just a few days ago. What she knew of his record isn't clear. Mayo said that the family didn't learn about her son-in-law's criminal history until a few months ago. Brittany Brewer's father confirmed that his daughter was among the dead. At a vigil Monday night, Nathan Brewer said that it's just a parent's worst nightmare, and I'm living it. The grim discovery could push the number of people slain in the mass killings past 100 for the year, according to the database maintained by the AP and US Today in partnership with Northeastern University. Oh, Crime Solver, you're fine, honey. Which case are you thinking about? Did they not find out about him using the phone in prison until after he got out? Okay, so K-Brass, so while he was using the phone in prison and he was sending nude photos to a minor, he ended up being charged for that crime in 2017. He was still in prison when he was charged. He had a 20-year prison sentence, which would have meant that he would have been getting out around the end part of 2023 if they'd have made him stay the whole 20 years. Well, he ended up getting out in October of 2020. They said that they let him out on good behavior. He was arrested the following month in November for the crime that he was charged for while he was in prison. Then they give him a $25,000 bond. And he bonds out. And then they want to blame the pandemic for the trial being delayed, when it's their fault. If he was charged for a crime like that, exactly, how is that good behavior? Like, they literally let him out 3 years early on good behavior. What they say, 16 years and 9 months he served on a 20-year sentence. How do you let somebody out who was charged while they were in prison? That's what doesn't make any sense. So he was charged in 2017. He was let out in October 2020. He was arrested in November 2020 and then given a $25,000 bond, and he bonded out. I don't understand why he got that low of a bond. Okay, Brad, you're very welcome. Okay, so let's see. Let me see if I can find the video real quick. I gotta jump over to YouTube to grab the video. Let's see, showing them. Exactly, showing them that he was a repeat offender, but for whatever reason, like they said, they hurried up and got him out of prison. And the fact that but another thing that I don't understand is if the Abby girl who was 14 and Brittany who was 15, they live close to him. Why was there not the whole the SO notification thing that they have, that whenever an RSO moves into an area, a new area, they are supposed to, or even whenever they get out of jail, wherever they move to, they're supposed to send out the little cards with their picture and their address and all that. It's like a however many mile radius around where they live at. Why wasn't that done? Okay, let me go over to News Nation real quick. Because the one video that Holly's mama and her aunt did with me feels like 17 minutes long. So I'm not going to play that one, but there is another one. There's actually two other ones. I'll play the one with Tiffany's dad in it. because Tiffany's dad says that there was an understanding between him and Holly that there would be nobody else around the kids. And even though the other two kids were not biologically his, he still claimed them as his, because the girl, the oldest daughter of Holly's, was like a year old whenever him and Holly got together, and the boy wasn't even born yet. And then his daughter was born. And he said that there was an understanding between the two of them that nobody would be around the kids unless there was a background check done. And Holly told him that there was a background check done on the guy and that everything checked out, that there was nothing on it. And I guess he believed her. Okay. And there's actually a new one that has come out. Came out 2 hours ago, that's saying that the Oklahoma police chief says that some of the bodies may have been staged, but I'll go back to that one in a minute. I want to find the one of the dad speaking and then of the grandmother. Okay. Okay, when was this guy? Tonka, he was released in October of 2020. He was then arrested November of 2020. And then he bonded out on a $25,000 bond. Okay, so it's going to take me a second so I can find these videos. I have to scroll down a little bit to find them. Like I said, the one is 17 minutes. I don't want to play that one because it's going to be too long. Let's see. All right, I'm going to play this one first. Hey, Daylight, how are you? Megan L., how are you? See, I fell asleep. That's terrible. Gigi, that is perfectly fine. You just needed your rest, that's all. Okay. All right, I'm pulling this one up to watch. All right, so this is Megan's mama. I'm sorry, not Megan. Holly. Holly's mama. That is in this video. And she's talking to Banfield.
That means that Jan Mayo has lost her daughter and her 3 grandchildren. And Jan is with us from Westville, Oklahoma tonight. We're also joined exclusively by Holly's aunt, Lynn Watt. Ladies, thank you for being here. And I know that you want to get your story out. You wanted to speak to us about what's happened. Let me just ask you this. Jan, have you learned anything else, anything new from the sheriffs, from the police, from the authorities who are investigating this?
The only thing that I've heard so far is that my granddaughter, Riley Elizabeth Allen, was shot in the head and died that way, and that my grandson, Michael Mayo, was undetermined cause of death. The other 2, they haven't determined yet. They haven't done their autopsies.
So your daughter, Holly, and her youngest, Tiffany, 13 years old, they haven't finalized the autopsies on those 2, so they haven't been able to give you a cause of death?
Oh, not yet.
Did the sheriffs or did any of the authorities tell you what they think happened just from being able to assess the scene?
No, I can't get any information. They're not releasing any information to me at all.
What did the authorities tell you when you got that just horrendous phone call?
All they told me at first was that Jesse was missing and the 2 girls that he supposedly kidnapped were missing. Nothing about my daughter or my grandchildren. I had to find that out from Facebook that they'd found 7 bodies. And nobody told me anything until 10 o'clock that evening that my granddaughters, my grandson, and my daughter were dead.
So
It
to be
was 10
clear, the
o'clock
police, did they, at 10 o'clock, did the authorities eventually call you to give you this news officially?
Yes, at 10 o'clock. And that's when they told me that my family was being transported to the Tulsa Medical Examiner's office.
Was there any other detail that they were able to give you during that phone call?
The only thing that they told me at that time was that they had been shot and nothing more.
Did they say that all of them had been shot? Because originally we had heard that just Riley had been shot, but did they say that all of the family members had been shot?
That's what I was told, that they had all been shot and that he took his own life.
Was there any indication at any time, Jan, that this man was so incredibly dangerous and to the point of being lethal?
No, there was nothing. I saw them Thursday at my granddaughter's choir concert, and everybody was happy. They were just smiling. They were in a good mood. Tiffy had gotten up and sang with her choir. She was getting ready to do cheerleader tryouts on Friday. They were just happy.
And did Holly know anything about his criminal background, his time served, and the charges of criminal rape that he had served that time for?
Yes. The only thing was he had lied to her and told her that the girl was 19 years old, not 16, and that everything was just a misunderstanding. He paid a young lady to portray the victim to sit down and have a talk with my daughter. And she told him, oh, it was just a misunderstanding. You don't get 20 years for a misunderstanding.
He paid a person to impersonate the victim of his crime to tell your daughter a lie, that it was her and that it wasn't a crime?
Yeah, it's exactly what he did.
And he never indicated at any time that he was a registered sex offender at that property where your family was killed?
No, my husband and I didn't find out until middle to late March, when my husband was looking up a coworker that he worked with to find out what his charges were, and Jesse McFadden's criminal history popped up that he was a registered sex offender. My husband then contacted our daughter to find out what was going on. Why were they there? Why was he in that house with our grandchildren?
And what date was that?
That was in March, probably about the 20th.
And what answers were you given when you confronted him with the fact that he was a registered sex offender?
Our daughter wouldn't let us confront him. She said, oh, it was just a misunderstanding. I've talked to the girl. At that time, we didn't know anything about the real victim.
It's an unbelievable story, Jan. I cannot believe that this has happened to you and to your family. Thank you for watching. Go to newsnationnow.com to find
Okay, yeah, I'm sorry. I was trying to get it unmuted and it froze up on me for a second. But yeah, he literally paid somebody. Hey, millennials, how are you? He paid a woman to go and tell his wife that she was his victim. And then it was a complete misunderstanding. Now, that woman who he paid and told his wife that, the other lady that was up on the screen, the younger lady, that was, hey, Justice Jane, how are you? That was Holly's aunt. That was her dad's sister. The woman that he paid got in touch with the family and told them what he had done, and she apologized. Now, in my opinion, she is a very disgusting person because she should have never, ever took no money or even agreed to say, yeah, I'll go tell somebody that I'm an SA victim of yours and it was a whole big misunderstanding. She should have never done that. Her coming back and apologizing now isn't going to bring those 5 kids back or this lady's daughter. Angie, I agree. Crime solver, I don't know if it's a crime, but like, what person, any respectable person with morals would go and do something like that? Because an essay like that's nothing to joke around about. That's nothing to lie about. That is nothing to, like, she literally, by her doing that, she left those 3 kids of Holly's in danger, and the 2 girls that were the friends of the kids that was there and that were murdered as well, put them in danger. And any other kids that came there, put them in danger. I say she should have taken the money and went straight to LE. I mean, I wonder if that is a crime, though. She's a very disgusting person. Whether she apologized or not, that's just, there's really no other way to put it. You know, was she that hard up for money that she had to go and lie like that? And then you have this other girl who was an actual victim of his that was supposed to go testify in court against him this week. You have her who was a true victim, who was victimized by him all the way up to the very end of his life by him blaming her for what he did. So even though it's not her fault, she's got to live with that for the rest of her life. Because even though it's not her fault, she's more than likely going to always wonder, well, is it my fault? If I wouldn't have went through with it, would they still be alive? Like, she's going to have those thoughts. And I pray to the good Lord that she gets help that she needs. And I hope that she never, ever blames herself, because it is not her fault. You see, a person who knowingly engages in conduct that creates a substantial risk or of death or serious bodily injury to another commits the offense of criminal endangerment. Thank you for that, Daylight. So therefore, she committed a crime. Did she not question, why do you want me to tell your wife this? Why do you want me to lie? Why are you willing to pay me money to lie to your wife about you SAing somebody and it only being a misunderstanding? To me, that is her saying, with her saying, okay, I'll take your money and I'll go lie to your wife, knowing that there's 3 kids in the house and that there's other kids that come to the house, that she was okay with the fact that he did this to somebody multiple times. I mean, he's already been in prison for doing it. It's what he got a 20-year stint for. Y'all heard me read what he did to the girl. He tied her hands and her feet to a bedpost. He was doing, while he was in prison for that, doing it to another child. So therefore, that means to me, in my opinion, she's okay with that. She's a disgusting person. She needs to go to jail. Because maybe if she wouldn't have done that, this lady and her 3 kids, along with 2 of their friends, would still be alive. Because maybe she would have realized that it wasn't a misunderstanding. He really did this. He is an RSO. Maybe she would have believed her parents whenever they come to her with the information and she would have packed her shit along with her kids and got the hell up out of there. Daylight, I don't know. And that was the first thing that came to my mind whenever I heard that that's what he did, was maybe she was hard up enough for money that's the reason. But I don't know that for a fact. Just that she did take this man's money. I don't understand people like that. Honestly, I don't. All right, let me find the video with the dad, with Tiffany's dad. Because he was clearly upset. And said what he would have done if he would have known. Because he said if he would have known that he was like that Jesse McFadden had those charges and he was an RSO, that his daughter would not have been in that house. And the parents, Brittany and Ivy, mostly Ivy, her parents have spoke out the most, are saying that the police aren't telling them anything. Just like you heard this lady here. She said the same thing as what the little Tiffany girl's dad said. They found out about it through social media. Not from the police. Okay. And like I said, there is that full interview with the grandmother, that video that I just showed with Banfield, the grandmother, and then the aunt. That whole full video is on News Nation's YouTube channel if y'all want to go check it out. Like I said, it's like 17 minutes long, so that's the reason why I didn't play the whole thing. But let me find... Okay. Hey, Miss Amir, how are you? Okay. All right, let me get this pulled up now. Let's see. Son is currently reserved in mental health. Okay. So this is going to be the video that I was talking about. With one of the victims' dads. So it seems like the wife should have dug deeper. I mean, it's sad because she believed him. And then whenever he brought this other lady in that lied, that he paid to lie to her, she believed him even more. She even told her parents whenever they confronted her about him being an RSO. She told the parents that she had talked to the girl and it was just a big misunderstanding. You know, he must have been very convincing. But then she lied to her daughter's bio dad and said that she did a background check on him, or according to him, I should say. He's saying that he asked her, and it's even in this video, was there a background check? And she said, yeah, but there was nothing on it. Okay. All right. I mean, it's just, I don't know. I don't understand it. The girl, it's just, it blows my mind that there's females out there that think that it's okay for men to do this to women, to the point that they will literally take money and lie and say that they were a victim of something like this. Hey, Rayanne, how are you? I have no respect. Whether she apologized to the family or not, I have no respect for anybody who will lie and say that they were SA'd at all. Okay, so this is the father of teen killed in Oklahoma murder-suicide who was told that McFadden had clean past. So I'm going to go ahead and play this, and while I've got it playing, I'm going to mute out.
Such an unbelievable story. Just the facts alone, let alone what we're learning just tonight on this program. I am joined now by Joe Guess. He is the father of the youngest victim, 13-year-old Tiffany Guess. He has his friend Sonny Summers with him for moral support. Joe, I am just so sorry for you and what your family is dealing with and going through. Have you heard any more information or details from authorities about this crime?
No, I've got one phone call, and that phone call was yesterday saying they found 7 bodies, and that's the only thing I've heard.
Who was it that made that phone call?
It was some investigator down there at the property, but that's all I know.
And an investigator was able to inform you of the fate of your daughter?
They said just 7 victims. They didn't tell me who it was.
How did you find out?
Facebook, the news on the online, and Holly's mother finally said or posted that it was the kids when they said on there confirmed.
So you've had no outreach, no contact from authorities in any way, even just for emotional support in this terrible crime?
No, not at all.
I am so sorry to hear that, Joe. Did you know anything about this perpetrator, this stepfather of Tiffany's, Jesse McFadden? Did you know anything about his history as a registered sex offender and as a rapist?
No, because my daughter would not have spent a second in the house. I would have brought the whole damn police force with me, or I would have dragged him out by the nape of his head.
Holly never mentioned anything at all to you about this.
No, the only thing we ever talked about was at the beginning of their relationship. We had an understanding that no one would be around the kids unless we both agreed upon it, and we did a background check, and we were okay with it. I asked if there was a background check. She said yes, nothing was there.
So you were lied to about the background, because as we're learning now from the children's grandmother, Jan Mayo, Holly did find out about the criminal background, but unfortunately, this
she was lied to
beast,
herself.
Jesse McFadden hired an actress to lie to her to say that she was the rape victim and that it was all a misunderstanding. Do you think that's why Holly didn't tell you?
I don't know. I know that from the bottom of my heart, I know that if any one of them would have told me anything, I would have been there. Period. I'd have been there. I don't care. Ex-wife, not. I'd have been there.
What was your last communication with your daughter, Tiffany?
It was last Thursday. I talked with her a little bit as I was talking with Holly. The kids were talking to me in the background. All the kids. I don't care. The older 2 aren't biologically mine, but I was there since Riley was 1, and Michael James wasn't even born. And we were married 13 years.
Those are all his kids. They all look to him as daddy.
So this is an additional blow. I didn't know that. I didn't know you had a close relationship with the other kids, Riley and Michael, and you had a chance to speak on the phone?
Yeah. As a matter of fact, it wasn't even a few months ago, me and Holly were still talking about possibilities of me going through the legal system and still adopting the older 2.
Even though she had married Jesse McFadden?
Yes.
Do you have any thoughts as to why she might have been thinking that you could adopt the children when she was married to someone else?
Because we've been working on it for over 10 years.
They loved him. They didn't look at nobody else as their daddy. This is their daddy right here.
They came to me the last season of During Track and was like, Dad, we know you're not our biological dad, but we don't care. You're our dad.
So Riley and Michael called you dad as well?
Yes.
I am just so sorry for what you're going through. This is just, it's such a tremendous, I mean, it's an unimaginable loss that what's happened. At this point, do you hold anyone responsible for having let Jesse McFadden out of prison, it looks like 3 years early, while a crime had been committed in prison, a crime that was similar to the crime he committed that got him into prison.
Yeah, he never should have been let out. The legal system completely failed. And not to mention, where's the sign? Where's the pink light? Where's all the indicators of somebody that's supposed to be a registered sex offender?
About the ball. Joe was kept in the dark. He didn't know anything about this guy's past. We didn't know anything about this guy's past until yesterday when it started popping up. And we're learning more and more about it in real time right now on the interviews you're doing, that people that knew about it, but yet for months and kept it privileged to their little circle and didn't tell Joe anything about it.
I imagine it might have been new information tonight that this sex offender had hired an actress to tell your ex-wife and the mother of your kids that there was no sex offense at all, that she was the pretend victim, and that it was all a misunderstanding.
I never knew Holly found out anything, and I never knew about a lie. I never knew about portraying nothing. I never knew about any of it.
When they found out what the public record was, and they knew
Go ahead.
that he was a sexual offender, and they knew that he had been in jail for all those years for rape, somebody should have told this man so he could protect his daughter and his kids. All three is his kids.
What would you like, Joe, what would you like us to all know about all three of those kids, Riley, Michael, and your daughter, Tiffany?
Well, they were taken from me too soon, but the best moments of my life. My oldest Riley was amazing, great artist. All the time asking if she could just draw me something. My son, always excited about showing me a new video game and talking for hours about video games and engineering and building this and building that. My youngest, straight A student, most amazing, sweet, kind person. Doesn't matter where I'm at, what I'm doing, she'll come running and jump in my arms. Daddy.
Track
And
star.
I'll never get it again.
Daddy's girl, track star. Fun-loving kids, man. Fun-loving, good kids.
We're looking at the pictures. We're looking at the pictures of them, and they really are beautiful children. And I am just so sorry, Joe, for your loss. My heart goes out to you tonight, and I hope you learn more information from the authorities in the coming days. And Sonny, thank you for being there for Joe, for his moral support. Again, our thoughts and our prayers are with you tonight, both of you. Thank you for doing this.
Thank you for bringing light to this story, man. We appreciate it.
Thank you for watching. Go to
Okay. Little Miss No Name, how are you? Tanya, how are you? I mean, that was just heartbreaking, y'all, honestly. Like, him, along with the grandmother, had to find out through Facebook or through social media that it was their loved ones who were murdered. Like, law enforcement couldn't even call them. Like, they didn't have the decency to call them and say, we found the body of your loved one. It's heartbreaking. And then, like I said, you have Ivy's family, her parents, who are saying that law enforcement isn't even telling them anything. And the sad part is this guy still wanted to adopt these kids, and they wasn't even his. He still loved them enough to want to adopt them. And now this Jesse McFadden dude just took them all away from everybody who cared anything about them. Let's see, something must be done to honor the victims. Biden should be there. Ted Cruz should be there. It's a national tragedy. Even worse, Kohlberger Where's Governor Abbott? Yeah. I mean, I don't understand it. Honestly. See, Boston doesn't even know he's in the world. I know that, I don't know if it was this case, the Oklahoma case, but I know that he was, I know he was briefed on the Texas one. Biden was. I can't remember if he was briefed on this one or not. Wait, King Scarlet, which guy are you talking about? The Jesse dude or the guy that was just on the video? Because she was married to both of them. All right, let me get in my email because I do have another. And this is going to be a video. Oh, Daylight. No, you're fine. No, this is the one we're talking about now. It's the Oklahoma one. Okay, just a second. Yeah, King Scarlet. Yeah, she was married to him as well. Oh, see, he was briefed on the Texas school one because it pushes. Yes, that is true. And I can't remember if he was briefed on this one as well. But I do remember seeing about the Texas one. Let's see. Okay. Pickle Me Elmo, I can't remember if I said hi to you too, but how are you tonight? And thank you for joining us. All right, and while I'm getting this video pulled up, this is actually the actual victim of Jesse McFadden's in this video. She speaks. This is the victim who he sent the text messages to blaming her, and she was the one that she had enough courage to and was going to go into court and testify against him. So let me get it pulled up. So like I said, while I'm getting it pulled up, if y'all have not done so, please hit the thumbs up if you don't mind. All right. Okay. All right, here we go.
Continues now. We showed you the pictures of each of the 6 victims at the top of this newscast. They are all believed to have been killed by Jesse McFadden, who's also dead.
Now, we told you McFadden is a convicted rapist. Fox 23's Michelle White is live after talking to the survivor of that 2003 crime. Michelle.
Shay and Sarah, Crystal Strong was only 16 years old when Jesse McFadden brutally raped her at knife point. He was 19 and dating one of her friends in their small community of Canadian Shores. But when he knocked on her door at 3 o'clock that morning, she never expected that he would rape her. It was a night Crystal Strong will never forget, but memories she suppressed and told few people for years.
Next thing I know, I'm being drugged through the living room into my own room, being tied up to my futon with bungee cords. My dad had those Western belts are made of cloth. I remember being tied up with those to the futon. And my feet were tied up and he had already undressed me completely.
She said doctors told her she would never be able to have children because of the damage he did to her insides. She has 4 children today, and she feared for all of their lives all of these years.
He had actually had a knife held in my throat, like a pocket knife type thing. And he was pushing really, really hard. And I remember when he was on top of me, I kept saying, I was like, Jesse, I can't breathe. And he's like, are you going to quit screaming, you effing B? And I was like, you got to get off me. I was like, I promise I won't tell anybody, dude. We're homies.
He threatened to kill her if she did. And then he went to work to hide her clothes.
He had his back turned. I just bolted out the back door butt naked and I ran clear down a half mile to the neighbor's house. I walked straight in her house. I didn't even knock, and I just collapsed to the floor. She goes, "Oh my God, baby, what happened?"
She called the police.
And so they came first, and then I had already called the cops while they were on their way, and the cops were looking for Jesse, and they found Jesse at the river with his wrist slit.
McFadden was charged with first-degree rape by force and fear on November 3rd, 2003. He pleaded guilty on November 14th and was sentenced to 20 years in prison. Strong feared for her life since McFadden raped her.
Not just him, but his family. He has a lot of family. Not so much fear, but fear like that they would, try to victimize me, my kids, like me getting off of a night shift and opening my door and somebody being in the back seat and being strangled, or because I put him away.
The news of the killing of 5 children on Monday that were near the same age she was when he raped her brought a flood of emotions. Shay and Sarah, to hear Strong's story is heartbreaking, but she says her heart is broken now for the families of the children that are believed to have been killed by McFadden. Coming up at 6, I'll tell you more of Strong's story. Live in Henrietta, covering news that matters. Michelle White, Fox 23 News.
Okay, give me a second, y'all, because that was not the current lady or victim, but that was the first victim. That's the one that he did that to, and he ended up going to prison for. So she's a strong woman, amazing resilience. Look at her now. Yes. Very, very strong woman. Yeah, that was the first victim. She's the one that put him away the first time. But that was not the video that I thought that I had. I thought the one that I had was actually the victim of the this last time that he got in trouble while he was in prison. Okay, heading to bed. Crime Solver, have a good night. See, I've tried to get some sleep. It's 3:10 a.m. here. She was able to be in chat. I hope everyone has a great night, morning, day. Stay safe, everyone. Thank you again for always being so kind. Heather, you're very welcome, and thank you so much for coming and hanging out with us. Avani, how are you? See, how did the man get a hold of these victims? Did he lie to them? Okay, so Avani, what he did is he ended up marrying Holly, which is one of them that was murdered. And is that what you're asking about, the ones that were murdered, Avani? Because he did lie to his wife. He actually paid a lady to say that she was one of his victims and that it was a whole big misunderstanding. This lady comes out, takes his money, says she was his victim, and the wife believed him. Heather, you're very welcome. Hey, Jody, how are you? So she stayed with him because she believed him. She believed the girl who lied to her. Therefore, her 3 kids were there as well. The other 2 victims, the other 2 teenage girls, were friends of her kids, and they were having a sleepover when the murders happened. So that's the reason why the other 2 girls were there. And the other 2 girls who did not live there, their families had no idea Jesse McFadden's background. Okay. And like I said, the woman who took his money and lied, She's a disgusting piece of shit. And Avani, you're very welcome. I just don't understand how anybody at all could lie about something like that. And I don't know. Are you talking about, Michelle, the ones that were murdered? I don't know. I'm sure that'll probably all come out after autopsy reports and everything come out like that. So I hope not. I hope they didn't have to endure that. Crime Solver, thank you so much for the super chat. And it says, Ashley and her blouse did a good job on that one. Proud of our girl and happy she hung up the phone to hung up the phone to BK for a minute. Yeah. But like I said, while that video was playing and she was talking to one of the victims' dads, why don't she take that burner phone that she was trying to call Brian Kohlberger on? And why don't she call some of these law enforcement in Oklahoma who let this guy out and ask them, why did y'all let him out? Why, when he had a 20-year stint for R-ing someone, the girl I just played the video of who explained her whole situation regarding Jesse McFadden. He was sentenced to 20 years. He pled guilty to it. They let him out in 16 years and 9 months. That's all he served. But while he was in there, he called another charge for soliciting a minor because he was sending nude pictures of himself to a 16-year-old girl on a burner phone in jail. He was charged for it while he was in prison. He was let out in October of 2020, and in November of 2020, he was arrested again for those charges and then let out on a $25,000 bond. He should have never been let out. When he was charged in 2017, they should have arrested him right then and there while he was in prison and kept his ass in prison until he went to court. He should have never been let out on good behavior, because obviously there was no good behavior if he's sitting there sending nude pictures of himself to a 16-year-old girl. Crime Solver, have a good night. So if he would have stayed in prison, he would still be in prison right now for the first 20-year stint, because he got it. It would have been at the end of 2023 before he would have gotten out. Or 2023, 2024. So he would still be serving that 20-year sentence. And on top of that, he could have been charged for the other one, arrested, and possibly starting that trial, and would have never, ever gotten out until he finished the sentence for the new charges. So not only did Jesse McFadden and his actions, thank you, Jody, put Holly and her 3 kids, the other 2 victims, which was Ivy and Brittany, and no telling what other victims or other teenagers that had went to the house that was friends with Holly's kids. Not only did he put all them in danger, but the dumbass woman who took his money and lied for him and said that she was one of his SA victims, but it was all a big misunderstanding. She also put all them in danger because she let Holly believe that it was in fact a big misunderstanding. And then the Oklahoma Department of Corrections, they all dropped the ball. And now you have a mother and her 3 kids along with two friends of her kids who have lost their life. I could give 2 shits less about Jesse McFadden if he's dead. I don't care. It would have been better if he would have went and this new victim would have got justice for what happened to her. But I could care less if he's dead. The other victims, the other 6 victims, they were the ones that mattered. And yes, I do agree, Roger. The girl who lied, she should be charged. I mean, she even had the nerve to go to Holly's aunt and her mama and tell them that she was sorry for what she done. Well, if she's going to do that, just go straight to the sheriff's department and tell them what you did. Because it's a bunch of bullshit. And she's just as disgusting as Jesse McFadden. Because by her taking his money and lying and saying that she was SA'd by that man and it was just a whole big misunderstanding, she agreed with what he did. She was okay with it. I mean, he literally lied to his wife. And this woman lied to her. And they both made her believe that there was nothing to it. It's just disgusting. Okay, hold on. Let me see if this is the one that I was looking for. Oh, no, that's not it. Okay. There is another one that they were talking about that it looked like the bodies had been staged. Let's see, just when you think that these cases can't get any worse, a new low. It's yeah. All right, let me go to my email real quick. All right. Let me grab this one out of my email real quick. Hey, Truth Finder, how are you? Amethyst, how are you? Okay, give me a second. Let me pull it up. And stop it from playing. Okay. Okay, so this is the one where it's talking about that it looked like the bodies had been staged. Amethyst, I'm doing good. A little disgusted right now about what I'm hearing regarding the whole Oklahoma murders that happened. But other than that, I'm okay. All right.
Injuries include Ivy Webster suffered one gunshot wound to the head. Brittany Brewer suffered one gunshot wound to the head. Riley Allen suffered one gunshot wound to the head. Tiffany Guess suffered 2 gunshot wounds to the head. Michael Mayo suffered 2 gunshot wounds to the head. Holly McFadden suffered 3 gunshot wounds to the head. And Jesse McFadden appears to have shot himself in the head.
Investigators say McFadden used a 9mm handgun that was bought by his wife in January of 2022. The chief also described where the bodies were found.
From the McFadden residence, which is probably 100 yards off the road, approximately a quarter mile south and east of the residence, there is a creek. And the creek is within a tree line, but just barely. Ivy was found on the west side of that creek, approximately 100 to 150 yards away. Brittany was found approximately another 100 to 150 yards away. Riley was found, and they were both on the east side of the creek. Then the other 4 decedents were all found together approximately another quarter mile more east than south, but southeast of where the 3 girls were found in a heavily wooded area.
This is a map that we have created based on the chief's description. He also said at least some of the bodies may have been moved or staged. The investigators found Holly's phone at the scene, that's the mom, and then found a second phone in pieces deep in the woods. They didn't find Jesse's phone, and the chief said that it is possible that the broken phone was his phone. Chief wouldn't speculate about motive or whether the murders were planned, but we might have some insight into that. On Monday, McFadden was set to stand trial for child porn charges. Back in 2017, that happened while he was still in prison. He was in prison for raping a 15-year-old at knife point. On Sunday, the day before the bodies were discovered, McFadden reached out to the victim in his pending case. She's now 21 years old and sent these messages via Facebook. Quote, I did exactly what I promised I would do when I got out. I got a marketing job, making great money, and was being advanced there. Been there 2 years now, and made a great life like I promised I would do with you. Now it's all gone. I told you I wouldn't go back. This is all on you for continuing this. Not entirely clear what the continuing refers to or what exactly he's blaming the victim for, the charges against him or the murders that he committed. Last night on this program, Holly's mother, the children's grandmother, told us exclusively that the killer had lied to his wife about his past rape conviction. And he did so by hiring an actress to pose as the rape victim and tell his wife that it was all just a misunderstanding. We'll keep you posted on this story. Thank you for watching. Go to
Okay. I know a lot of people don't like Ashley. I don't really care for her sources, but she has a huge platform. She can make a lot of noise by getting in touch with Oklahoma and asking them why did they let this man out of prison. Hopefully she does that. I don't know if she will or not, but hopefully she does. And Amethyst, I don't get the whole stage in the thing, but what's sad is that what it sounds like is he murdered one of the girls and then walked the other two, murdered the second one, walked the last one, and that last one watched her two friends die. Almost like a sophisticated criminal hiring a liar. It's too easy to look stuff up with computers all over the place. She should have still. I agree, Pickle Me Elmo. I really do. Hopefully they do something to the lady who lied. I mean, she's clearly admitted it. It's like the whole system is responsible for these 6 people's deaths. Like I said, Jesse, I don't even care about. But the other 6. You know, if he didn't want to go back to prison, he shouldn't have did what he did. But if he didn't want to go back, take your own self out. And I hate to say that because then the victim doesn't get the justice that she deserves. But at least it would have left the other 6 victims. It's just, it's a sad situation all the way around, honestly. All right. Okay, real quick. And I do have another live scheduled at 2:30, but I'm gonna start it as soon as I'm done with this one. So it doesn't matter if it's just sitting there waiting on me to start it. It's just the Lori Vallow audio for today. Let's see. Always Google, guys. I dated, never found anything. Well, found one tiny misdemeanor charge. And when a guy was super young, grown men with records are cringy though. Yeah. I mean, it's always a good thing to do a background check. And if somebody doesn't, and it's the same thing with, like we were talking the other day about people who you're looking into to babysit your kids. It's always a good thing to look into people and check their backgrounds And if for some reason they don't want you to do it, there's a red flag. Like, don't let them babysit your kids. Don't date them. See, if you posted that online, why didn't everyone report it? No, the issue checked out. Wait, Tanya, what do you mean post it what online? I mean, honestly, P-Fox, the only thing I can say, it's a sad situation. Honestly. Princess Megan's just here eating. And Tanya, if you're talking about like the things that he was saying about that he had a marketing job and had a good life and all that, he didn't post those online. He actually sent those in a text message to his latest victim. Let's see what he wrote to the victim from jail. And I believe whenever she received those text messages, she took them to and showed them to law enforcement. And the only other thing I can say other than this being a whole sad situation was that the Oklahoma Department of Corrections completely dropped the ball on this one. I bet subscriptions to background checks will go up. I mean, you know, it's got to the point it can be a matter of life and death if you don't look into someone's background. See, because there were so many of them, you would think that at least one of them could have gotten away from him. And there's no telling, because like the grandmother had said that he's very controlling, and that like if the kids, the Holly's 3 kids, if they would go to the grandparents' house, he had a tracker on their phone. He was probably abusive to them, telling how they were treated or how Holly was treated. You know, I don't know. I don't. It's a shame that one of them couldn't have. Let's see if he drugged him. Possibility. I mean, that we won't know until autopsy reports come out. Let's see, good gift idea. Yes, Marissa, for sure. Or even if your daughter, like, you know, some kids are like, you know, if you were told them, I'm going to get you like a subscription to do background checks, and they're probably like, okay, yeah, whatever, I don't need that. If any of y'all do that for your kids and they're like, I don't need it, bring them in and let them listen to a true crime YouTube channel and see if that changes their mind. Because like you hear a lot of stuff on the news, but you hear a lot of stuff on YouTube. And let's see, cornered them all in a room. See where they couldn't get out. I don't know. He could have drugged them. I don't know. See, I think that once someone does something to a child, they need to never be able to do that. Okay, so I do know, and I heard this yesterday or day before yesterday, that down in Florida, they are getting a bill passed, and I believe it's supposed to go to the governor's desk, and they were just waiting for him to sign it. That, which it shouldn't be, the age should be higher than 12, but as of right now, they have it that if anybody does that to a child 12 years or younger, and they are convicted, it is automatic death penalty. I think that if anybody is convicted of doing anything like that to anybody, no matter the age, it should be that. Because honestly, I don't think that you can rehabilitate someone who does something like that to people. And therefore, it should be an automatic death penalty case. And that's, I mean, it's a start. 12 and under, it's a start. Hopefully, more states will follow suit behind Florida. But then I think that they need to up the age to it be a no age at all, just if you're convicted of it. it should be that. Kind of like a first degree conviction. It can be a death penalty case. It should be that for an SA charge. But that is just my opinion. I know some people aren't for the death penalty, and that is fine as well. But that is just how I feel about it. Because if you get, like this dude did, a 20-year sentence, and then you get out in 16 years and 9 months. Well, you've served your time, and you get out and you get to go on about your life and start over, or whatever it is, get married, have kids, whatever. Well, the victim, for the rest of their life, they're scared. If they have kids, they're scared for their kids. I'm pretty sure it's hard for them to have a relationship because of what someone done to them. So they continue suffering for the rest of their life while the person just goes in, serves a prison sentence, gets out, and that's it. Let's see. And also, at the least crimes against children or people against their will, you should have to do the entire sentence. Yeah. I mean, this man went in and admitted, like, he pled guilty to doing what he did to the girl that was on that video, telling what all he done to her. Like, he pled guilty, and they still let him out early on good behavior. How the hell do you let somebody out of prison on a charge like that for good behavior when they were charged 3 years before that for the same thing while in prison? Like, where are they getting the good behavior from? That's where these families need to get together, or these victims. They need to get together, and they need to go to the Oklahoma Department of Corrections and ask them, where the hell is the good behavior from? Like, where are they getting that from? Who let this man out? Who signed off on this man's release? Because that is the person, whoever's signature is on that release, that is the person who is responsible for this. Because had that man not gotten out, he would still be in prison today. And these 6 victims would still be alive. It makes absolutely no sense. Let's see, they should put a big fat tattoo on their forehead when they get out. Stella, yeah. Stay away from me, I'm a convicted felon. I mean, we tag animals, why not tag? Yeah, that should be mandatory. Before you are released from prison, you have to get RSO put across your forehead. That way, some of these RSOs, they'll move, but they won't turn it in that they've moved. They don't keep up with their registration and all this and that, which is a crime. They get arrested for failure to register as an RSO. They still should have to register. They still should have to send out that little card to the people in their neighborhood or in the vicinity of where they live at. They still should have to do that. But yeah, they should have big RSO tattooed across their head. That way, if they don't register, everybody who comes in contact with them still knows that that's what they are. Let's see. They should have a sign. Yeah, and sign. Any way that they can make it public knowledge that that's what they are, they should do it. I don't give a shit. They got to paint their house orange with purple polka dots on it, with a big sign in the yard with their name and their face, with a tattoo of an RSO across their forehead. Like, any way to get it out to the general public that that is what they are, that's what they should do. For anybody who harms anybody in that way. Let's see. She would not have married him if he had been, if that, yeah, that is true. She would have known that is what he is. There's no misunderstanding. She would have known 100% that that's what he was. Tracy, thank you so much for being a member for a month. And she says, great creator, mods, and chat. Thank you so much. Well, Tracy, thank you so much. That was very nice. People need to speak out and let it be known that we won't tolerate short-term violent offenders back on the street. I don't understand. Like I said, these families, Holly's parents, her aunt that was up there with her mom, like, they need to get an attorney and they need to go to the Department of Corrections and find out who signed that paper to release him. That's what they need to do. They need to get it looked up if he had any type of write-ups while he was in prison. Other than the one that he was convicted for in 2017 for having the phone and sending the nude pics. Did he have any other write-ups after that? Before he was released? Like, where are they getting the good behavior? That's what they need. That's what they need to find out. See, they'd all wear big hats to cover their foreheads. Then we'd be seeing big hat people all around. I mean, there would have to be some way. Hell, tattoo it over their cheek, RSO. Like, there would be some way that they wouldn't be able to cover it up. Let's see. You see this all the time. These people commit these crimes and only get a few years. Get out, do it again. Justice system is a mess. The justice system is completely fucked up. That's what it is. Excuse my language, but I'm just being honest. Let's see. Do they have to monitor? Wait. Do they have to have monitored visits every month or have a check into somebody? K-Bras, they are. I mean, it seems like he would have been let out on parole. I mean, he didn't finish his sentence. He was only let out on good behavior. So it seems like that he would have been let out on parole until the end of his sentence would have been up, which would have been, I'm going to say 2024, because they said that he was convicted in 2004. He did the crime in 2003, convicted in 2004. He got a 20-year stint. That would have put him getting out 2024. So when he got out in 2020, he should have been on parole until the end of that 20-year sentence was up. So therefore, he would have had a parole officer. He would have had to have had either weekly check-ins or monthly check-ins, however they would have done it out there. He would have had all of that. But apparently he wasn't even having that, because if he would have been, then Holly would have known, well, he was in prison and it wasn't a big misunderstanding. He wouldn't have wouldn't have been able to have any weapons in the house. And they more than likely wouldn't have let those 3 teenage kids in the house. Because like they said, those kids were the age of the victims that he did that to. A non-removable cow tag. Yeah. Something that everybody could see, like, that they couldn't hide. And I bet you if you started doing stuff like that, I'm pretty sure there would still be people who would do something like that. But it might calm it down some. Because you do have people out there who don't care what other people think of them in that aspect. They don't care if people know that they're an RSO or that they've hurt people or anything like that. Instead of putting the cow tag in their ear, put it in their damn nose. Like, how they gonna cover it up? I mean, they could still cover it up possibly with a hat or something like that, or a beanie or something. Put that shit in their nose. Let's see, he should have been better supervised by his parole officer. Yeah. I don't understand it. Let's see, it's sad that these RSOs get less time than the Grizzlies got for nonviolent financial crime. I mean, honestly, Amethyst, it seems like that the justice system has their priorities ass backwards. They will give somebody a life sentence for something that's not that bad, but give someone who are somebody 20 years, who then gets out of prison and murders 6 people. It's just ridiculous. Let's see, parole officers should also be held accountable. Yeah. 7 for Julie, 12 for Todd. So Amethyst, they ended up getting 7 years and 12 years? I remember seeing that they were supposed to go to prison, but I didn't know what exactly it was that they did. So when my kids were younger, I lived in government housing, so mostly single women and kids in the street. They housed an RSO. There they told us that RSOs have to live somewhere. Well, honestly, Epstein's Island is empty. I mean, ship their ass over there. It's an island. Tell them fend for themselves. Learn how to fish. Do something to survive. See, don't forget to hit the likes. Yes, y'all, please don't forget to hit the likes. I get that they've got to live somewhere, but they don't have to live where there's other kids around. Because, I mean, they're not supposed to live within so many feet of a school or a park. Ain't that right? So if that's the case, if you don't want them living close to a school and you don't want them living close to a park, then why should they be able to live close in housing like that where there's other kids? Why should the kids who need a place to live be put in danger because an RSO needs a place to live? That is true too. They put people in prison for marijuana longer than they do RSOs. Let's see, I've seen somewhere where they had trailer parks dedicated for them to live in their own community. So that's what they need. That should be mandatory for every state. Have one big ass mobile home community or tiny house community or whatever dedicated to them. And that's it. Or like I said, stick their ass on an island somewhere. But putting them in public housing or in neighborhoods where kids are, when they don't even want to live next to a school or a park, it's not, in the same sense, it's not fair. In Washington, we had a whole island for them called McNeil Island. I mean, they should have that here. They should have it everywhere, honestly. Keep them away from people. I mean, because they're, people don't want someone who hurts kids or hurts women. They don't want people like that around them. They don't want people like that around their kids. See, I'm sure the Department of Corrections as a whole and then each person individually involved with the decision. PFOX, that's what they need to do. Holly's family, those 3 kids, family, and the guy, Tiffany's dad, is saying that he was wanting to adopt. I don't know what the situation is with the older 2 kids and their dad, but if he was still willing to adopt them, I don't know if he could sue on their behalf. I'm sure Holly's parents could. And then Ivy's parents and Brittany's parents. They should all go in like it's one big class action lawsuit and just sue the shit out of them. Because maybe if you do that, then Oklahoma Department of Corrections will do what's right from there on out. See, I'm not going to say what I think they should do to them, but I'm sure y'all can guess. Oh, well. I'd say something worse than castrating them, honestly. I say cut all the shit off down there and then make them eat it. And then still put them on an island. See, this is Australia and they don't have to register as far as I know. Really? Must have got lost? Like here, they have to register. Before they can even get out, they have to have a place to live. They have to register and then they have to send the little cards off to people. With their pictures, addresses. I can't remember if they have to put their charges on it or not. They probably have to put their charges on it too, but they have to put their picture and their address on it. Let's see if they brought back public hanging. I bet you people would straighten them quickly. So years ago, they would have made it. They wouldn't have made it out of prison. Yeah, because years ago, Tanya, people in prison, they didn't like people who done stuff like that. But I'm pretty sure now they probably house them all together with their own kind like that instead of probably out with where they would be hurt with the other inmates. Where the castration chemical leads to more violent assaults. So I like the pew-pew idea. I don't know. It's sad though, honestly. The 6 people had to lose their lives and all these families are affected because law enforcement didn't do what they were supposed to do. Okay, let me read this real quick. All right. And what is sad is that people who do something like Jesse McFadden did and hurt people and did it while he was still in prison and still got out of prison. He was in jail for 16 years and 9 months where he got 3 meals a day. He had a place to sleep at night. Might not have been the most ideal conditions, but he still had it. He didn't go hungry. He wasn't homeless. But yet we got veterans out there who can't get medical attention. They're homeless. They're hungry. They can't get work. But yet they would treat a criminal like Jesse McFadden better than they would a veteran who fought for our country. And that is disgusting. Honestly. So there should be billboards that flashes all the local RSOs in the area. Yeah. Because, I mean, they can't hide that. Like, let people in their area know what type of person they are. If they don't want people looking at them like that, then they shouldn't do the shit. All right, y'all. I'm about to end this live. And I do have the Lori Vallow trial, the audio from today. One of Lori's friends, Audrey, forgot what her last name is, testified today. And then Ian Pulaski is also on the stand today. So I'm going to end this one. The other one's already scheduled. If anybody wants to come join us, we'll be over there for that one. I think tonight it's only like 3.5 hours, so it's not that long. I mean, I wonder if somebody could, like, because I know that the billboards, like, they cost money to run them, but there ought to be some type of program that they can use those certain, like, the billboards just for that, nothing else but for that. Michelle, it's going to be on this channel. It's just going to be a different live. I'm going to end this live, and then the other one's already scheduled. It was actually supposed to start 25 minutes ago, but it's still sitting there waiting for me to start it. All right. Well, I'm going to go ahead and end this one. Like I said, if anybody wants to come over there, you're welcome, Michelle. And join us over there. That will be awesome. It should be really interesting to hear what Ian Pulaski has to say. And I've heard that this Audrey woman, her testimony was like explosive. Hey, Linda. So thank you, Linda. I'm on my way over there, honey. Thank you all so much for coming and hanging out. Thank you, Vapor and Troll, for the gifted memberships. I know somebody, Crime Solver, for the super chat. You guys are awesome. Thank you so much for coming and hanging out and listening to all this. I know it's hard to hear and all that, and it could be triggering for some, but I do appreciate all of you coming and hanging out with us. And I love you all, and I hope y'all have a wonderful night. And like I said, I'm fixing to jump over to the other live. If y'all want to come join us over there, that would be awesome.